approached, but he had said no. This after your lordship, now if your lordship will permit me to place, then I'll place her lordship. Because if lordship, this is this specific repeated request, my lord, by the
Mr.
petitioner.
This is a review matter.
Yes, my lord.
Okay, where is the other side counsel?
Other,
You are there.
My lord.
Okay, you have served the copy.
no copy,
Mr.
because he was not appealing.
Mr. Sanapati, have you served the copy on him?
Not yet, sir.
No. All right, if you admit this, then only question arises.
Yes, my
But
lord.
in a review, there is
My lord,
already
yes, my lord, I am
appearance. Why
conscious
don't
of
you
that.
serve copy on him?
I didn't know that because
Mr.
review matter,
Mishra,
I
Senior
didn't know
Counsel,
that
Mr.
it-
Mishra,
Sorry, my lord.
you have annexed annexure 1, 2, and 3.
Yes.
Can it be annexed now?
No, I'm conscious of that.
So
I'm
please,
conscious of
so
that,
I mean,
yes.
you are throwing the gauntlet to their hand by
Uh,
bringing on matters, and these are all old records.
My lord, I'm conscious of that, but I had no alternative
No,
but to.
the only concern is that after almost 30 years, this order was
No,
passed.
my lord, that part I will explain,
So-
my lord. If
so-
lordship will permit me.
No,
Actually,
it's
there
not a
is
question of,
no
no,
loss.
we are not seeking any explanation.
No, I'm not seeking.
No,
I'm,
we are not seeking, and we are not there.
my lord,
You
30
must
years.
appreciate the concern of the court.
Yes, sir.
That I wanted to
I'm
say.
conscious. Your lordship has also recorded that. My lord, if lordship will permit me, actually, that is the whole by lordship kindly see page 36 of the.
Questions you should have asked to the client when Mr. Mishra should have, Senapati should have asked that whether these documents were produced before the court,
No,
whether you can, your client must be aware of these things. That
No,
is
it was not.
before briefing the senior counsel.
It was not put.
Those documents are not.
So then
It is not-
on the it should be dismissed immediately,
It is-
because you have made that ground
My lord.
that despite exercise of due diligence, you did not produce. Because these are all your own documents,
Yes.
and this has no relevance also for the adjudication.
But independent of that, my lord, lordship will look at the lordship kindly look at your lordship's judgment dated page that para 60.
No, we are not there, since it is
Okay.
being adjourned actually.
Oh, I'm
so-
sorry.
And
If your copy will be served, my lord, may I pray tomorrow, third day after tomorrow? I'll serve copy right now. My learned friend will serve copy on him right now. Let's take it up day after tomorrow.
With due respect, your lordship,
Counts for review.
My lord, ground your lordship kindly to para 16 of the judgment. Para 16 of the judgment. Page 36 of the review petition, na?
yes.
Page 36 of the review petition,
Page 36 of the brief.
my lord.
36 is the judgment part.
Yes, judgment. I'm referring to your lordship judgment only. From that, I will submit the
Yeah.
ground. My lord. Up to para 15, my lord, because your lordship has set aside the trial court's order for that petition is my lord.
Hmm.
Therefore, now I seek review of the direction content from para 16 onwards. My lord, may kindly see for a minute, my lord, I may be permitted to read that portion. This court finds therein that conditional dispute was entertained in the year 1993. Litigation period of the Honorable Apex Court in 2013. We are now in 23. There is almost a passage of 30 years in the meantime. Some workmen have already died. Many have attained the age of superannuation, but all of them are yet to get a single pie in spite of their condition of each workman involved. They are mostly precarious, even after they have got award directing the institute in 2019. Well, your lordship kindly see, there is no, the award is something different. Award is not reinstatement. The award is for regularization of service, and they were in service at that point of time. They automatically, of their own volition, they left in 2001, 2003 respectively. So that is it. So, should your lordship kindly see the award, my lord? Read petition. Read petition, your lordship kindly report to read petition. Read
No,
petition, my lord.
how to challenge this
My lord, I
objection?
challenge because there is a
And Mr. Mishra, you know we are in review.
yes, my lord, I am very much conscious
Therefore,
of that.
unless it is
My lord, but
perverse, unless it is contrary to law,
My lord, what I implicitly submit, my lord,
Yes.
your lordship at the reinstatement in 99. There was no, so your lordship passed this order
No,
considering
Mr.
the fact.
Mishra, actually,
Sorry, my lord.
perhaps we are not briefed properly.
Sorry, my lord.
You have not been briefed properly with greatest of respect to Mr. Senapati. This is a 33C2 proceeding.
Yes.
So,
33
so
should-
what is the scope of court entertaining all these things, whether they were in service,
No, but
not
your,
in service?
but your,
33C2 proceeding post order of the Supreme Court. It was confirmed by the High Court,
my lord,
confirmed by the Supreme
that part I am showing, my
Court.
lord.
So
33
please,
should
please
be
be
not
conscious of the
maintenance
fact
at all.
that, please kindly,
Sorry, my lord.
kindly
Sorry,
just. So this 16 is in context of 33C2. So in fact, I mean,
My lord,
I may not have, I may not have much experience, but my learned,
my lord is expert on that.
so my lord is expert of that. So 16 is in context of 33C2.
No, my lord, only one thing I wanted to what is the award?
Only thing is that I sat in the bench for a long and this persuasion for the management to settle at a, for a
My
settlement.
lord, that
That
also,
was the effort of the earlier bench.
yes, my lord.
Thereafter, it was transferred to our bench here, and so 16 is in context of 33C2. It's a
My lord,
33C2
33
proceeding.
my humble submission, 33 C2 absolutely has no, is not maintainable at all. Because the award your lordship kindly 33 C2 your lordship kindly.
All right,
See,
come to award, all right,
You
come to award.
have only challenged
So
33
33 award,
proceeding
your
on ground
lordship
of
kindly
lack of hearing.
Yes, my lord,
So that
because
you execute
I have also learned something page 41 of the writ petition lordship kindly see. Page 41.
41 of the,
Read petition. Read petition. I didn't want to make the review bulky because read petition is already there. So in view of the
yes.
lordship
No,
kindly,
first of all, yes,
sorry, madam.
come to that head note of the annexure.
Note, madam.
It is
My lord,
annexure?
reference, my lord. Yes, my lord.
It is annexure.
Page 23. Annexure 1, page 23. Yes, I should have
22.
actually brought it to lordship.
So this is the award in 10-2.
Yes, my lord, your lordship kindly see the
So this is
reference
the
first.
main award.
Yes, this is the award.
Ah,
This is the
main
award
award.
which is the subject matter of the
Yes.
33 C2.
In
My lord,
view of
kindly
my
see
findings,
page 23. My lord, kindly see the reference first. Page 23. The reference first.
Mr. Mishra, we have made it clear. The read petition is arising out of a 33C2 proceeding. Therefore, illegality and that too after the Supreme Court confirming
Yes,
the
my lord, I am conscious
award.
of all these things.
Therefore, we can't go to any merit.
No, I am not continuing the merit of the case, my lord. Only saying that because there was your lordship found that it is a reinstatement in service, that is not fact. There is no question of reinstatement in service. The award is for regularization of service, and they were regularized after the award was implemented. After the award is implemented.
Is it your ground in the review petition that the read court has gone beyond the award? So you make it clear, then we'll answer it. So that was my humble proposition, that being conscious that it is 33C2, 16 has dealt with that, and my understanding is that the read court has not gone beyond the 33C2.
My lord,
whatever was award. So basically, you are saying 33C2 is not maintainable.
We are
Yes.
coming to that. All right. Yeah.
So
my lord,
so that-
look at the award. I am looking at the award.
and you see, your ground of challenge before the read court is that you were not given an opportunity of hearing.
That part, my lord.
So
we have remanded
that part to compliance of the award.
that part,
So
my lord.
that is again conditional.
That part, my lord. The
So
petition
that
is
risk-
for that.
So
my
you
lord,
see, that risk they are compelled to take.
no,
you see,
only one thing.
Initially, the endeavor was for almost a year to arrive at a settlement. But
Ultimately,
somehow it was even they agreed
Wow.
that whatever amount will be given.
No, that is not
given.
what the
no.
petitioner stated, my lord. What the petitioner stated.
No,
There was a
it is not
discussion.
like that.
There was a discussion, but
To
they
that extent, I am.
were adamant on getting
There were
the full amount.
several opportunity. The thing is that you may blame them. That's another thing.
No, I'm not blaming them.
No, it's you means not the lawyer.
No, I mean,
The management may
the,
blame but it is a
Wow.
fact that since 25 years after they are this fruit of this award, they are not enjoying.
my lord, your lordship, the award, but first of all, 33
So
C2 comes out of the, had there been a question of reinstatement with backages, then the award, the 33 C2 application would have been
Mr.
maintainable.
Mishra, once regularization direction there
Yes.
and it is confirmed in apex
Yes,
court,
yes.
so they deem to be continuing from the date of regularization direction.
Yes.
So
But
once
they were continuing also.
So
They were also in
some of
employment.
them were continuing,
They are
but
employment.
not all.
Their
Now,
employment.
now they landed in a 33C2 proceeding.
33C2, my lord, your lordship's experience, my lord.
Use.
33C2, my lordship's experience, I will submit. 33C2 will be when there is an award to the defense.
So now there is no order, final order in the 33C2.
No, fine, that is the
because
reason
it
why your
landed.
lordship. Now, what happened, my lord? But I am not saying it. I am saying that your lordship was directed to deposit the entire amount which has been awarded by the
Yes, it
impugned
was
order.
awarded long
The,
since.
the tribal labor court has awarded around 17 lakhs somewhat per person for workmen
In the
to,
meantime,
and you
what-
also
what has
directed
been
to
passed?
deposit the entire amount, which is more than around 4 crore. It is just not possible on the part of the petitioner, because even with the petitioner, it is just not possible to deposit the entire amount. That is the reason why the review petition is filed by Lord.
Mr.
Lord
Mishra,
Can
it
see,
is difficult.
and-
It is difficult to understand. The one side is poor workmen, one side
My
is
lord, poor,
mighty,
they're not at all
okay
suffering.
workmen.
No, I'm not speaking to poor, my lord. I'm not, they are not at all support because 2000.
Mr. They may be rich or.
No, I'm not speaking
According to you,
about
they are
they
so
are-
rich that
I
they
do
can.
not say,
No, no,
sorry.
kindly appreciate, there is an award.
Yes, there is an award.
An award confirmed by the High Court and the Supreme Court.
Award has been
So this
implemented.
court- this
The award has
court-
been implemented by regularizing their services. The award has been implemented. So there is absolutely no issue so far as the award is concerned, implementation award is concerned. So far as the computation money, my lord, the award, my lord, the award is simply regularization.
Sir, your case is before this court is that you are not given opportunity to do
My lord, that-
in the
that-
33C2
yes,
proceeding.
no,
So that has been remanded.
yes, that doesn't,
So
but
that
your
has been
lordship,
remanded.
your lordship was directed to deposit the
course.
entire amount, whatever was in the award, directed by the
Mr.
labor
Mishra,
court.
we
And
directed, Mr. Mishra, we directed for the reason there has been long time.
My lord,
passing.
your lordship, my
therefore-
humble submission is that-
Therefore, if ultimately, if we assume that yes, same award comes after 2 years or 1 year, then the amount will be highly
my lord,
inflated.
your lordship kindly
So
say,
therefore, it's
by
a
this
condition.
process, by this
Deposit
process,
this much, you get opportunity
can-
because you are now making the workmen suffering.
no, not at all. That I wanted to
No,
submit,
no,
my lord.
suffering means the award in their favor, the order 33
The order has
taken
been,
away.
award has been implemented. They have been regularized. Thereafter, they themselves.
Then you argue, so listen,
my
Mr.
lord,
Mishra, then you argue before the 33C2.
yeah, I'll
Yes, they
be
are
not
not
that.
taken.
Well, I am not. The only thing is that by your lordship direction to deposit the entire amount with 6% interest, that the petitioner effectively cannot be permitted to proceed in the labor court because of the deposit is around 4 crore. It is just not possible on the part of the petitioner to
That is a
deposit. That is the
different
reason I have
approach.
statement
They are not there.
given back statement and all that. 4 crore around somewhat. Your lordship, that is the reason why, my lord. Otherwise, but there is no necessity of we could have taken. We'll take all the grounds in 33C2. But how if you are not able to deposit the amount, how we can deposit? How we can contest the proceeding, my lord? That is the reason. We can contest the. I am not taking into grounds which I will raise before the 33C2 court. That is a different issue. My humble submission is that, and so far as suffering, your lordship kindly see, they in 2001 they themselves left the service and they were in gainful employment elsewhere because basing on that year. And thereafter, my lord, after the award has been implemented, also they joined, and after 1 month again they left the services. That is that they have gainful employment. So I am not speaking about
That is open to be argued in 33.
That is the reason why the lordship, that is the question of if so lordship deposit part is the only part which is, that is we are agreed by the only deposit part, not the that part. Your lordship has we are really petitioner is really obliged to lordship sir, because lordship has allowed the writ application to that extent.
And again, we have said after releasing of sum of rupees 3 lakhs, the balance.
But out of that amount, your lordship
will be
deposit.
kept in deposit.
So the subject to proceeding will continue subject to deposit the amount.
Absolutely, they are now
Yeah.
made, you have made
So-
them to suffer. How many years
Suffer-
they will
no.
be struggling?
First of all, they have not suffered. Then, my lord, because they have not suffered. Anyhow, whether suffered or not, that is a different issue, my lord. But the thing is that by this process, my lord, I will be out of the court. I will not be able to deposit the amount. I will be out of the court. Comes to around 4 crore. I will be out of the court. That is the reason why what I humbly pray, my lord. Your lordship, your lordship directed them to deposit this was within 4 months.
What are the grounds in review petition?
My lord, review petition by that there was
You are incapacitated.
no, my humble submission that the award is not executable in 33C2 proceeding, and that aspect the material, and there was your lordship were carried away by the reinstatement in 99. Actually, there was no reinstatement because they are in service then. they're in service then. Question reinstatement doesn't
No,
arise.
actually, the lordship did not get carried away. Supreme Court got carried away.
No,
Earlier, so that is the, you see,
our part is there, my lord.
Unfortunately, all these arguments, you are arguing as far as the merits of
all
the,
were
or the
made.
award is concerned.
No, my lord, I am arguing
So
only on the
you
question
should
of
have filed
review.
a review before the Supreme Court telling that the lordships got carried away.
No, my lord, the award is final and binding. Absolutely, there is no point in
If you do
discussing
not
about
want
the
to
award.
enforce the award confirmed by the Supreme
Yes,
Court, you
my
have your legal remedies open to you. It is your lookout, but not in this proceeding.
No, what I humbly submit, my lord. Had the award said about the then certainly I would have been out of the court.
Not a case.
Had the award been there for reinstatement of service or back wages and etc., that was not the reference at all. And there was no award at all. The award is with respect to the reference. That is the reason my humble submission is that your lordship's reinstatement 99, that is actually probably it could not be brought point out to your lordship.
Mr. Misra, whether we have indicated reinstatement or regularization, it may be a mistaken question of fact, okay? But ultimately 33C2 will be guided by what?
Yes, by
the award?
by the
So language of the award will be gone into there.
gone into and
Therefore,
certificate on that I can raise that issue. I can raise that issue there. The only problem is that now your lordship direction, para 16 direction to
That's
deposit
right.
the entire amount.
Right, but that
That part only by that process, my lord, automatically I will be out of the court because I will not be able to come.
We'll pass order on the entertainability of the review itself.
Sorry, my lord.
We don't admit presently. We'll find
My lord, dear lord,
find difficulty in admitting even.
Your my lord.
All right.
Huh?
Hearing on admission in the review application concluded. Yes. Order reserved.
Okay. Diploma.
Item number 2.
Award of the labor court within an ex parte award without giving opportunity to me. That is why it is there. I have filed a restoration miscase for recalling that award. That restoration miscase is not being able to be taken up by the court. That is my small grievance, Your Lordship.
Is not being taken up.
Yes.
So that's the short
That
prayer.
is the short grievance, nothing else, Your Lordship. That is the short grievance, Your Lordship. Annexure
What is
6, Your
the
Lordship.
position of parties there?
My lords?
What is the position of party? Restoration miscase, has the notice been issued?
No, it has not been entertained, Your Lordship.
No,
That is why I am
entertained
before your
means
lordship.
rejection.
No, not rejection also. It is not registered.
It's not registered.
Yes.
Where is your plea that you have filed on which date? and
Yes,
it
my
is
lord.
lying
My lord.
there?
I have filed, Your Lordship. Just a minute. Yes. My lord. Your Lordship, come to page 13, Your Lordship. Page 13, para 18, Your Lordship.
Hmm.
Starts with para 18, your lordship.
Yes, on receipt of notice of
Yes, my lord.
notification.
Copies
Yes.
of the relevant order sheets were obtained by the petitioner on perusal of the relevant order sheets of so and so. It was evident that the petition dated 22/2 was not reflected, much less considered. Your lordship may come to the 10 lines after that, your lordship. On the contrary, the labor court proceeded unilaterally and unjustly behind the back of the petitioner and most abruptly had closed evidence, and the award has been passed ex parte in the absence of the petitioner. The petitioner immediately sought to submit a restoration miscase before the labor court Jaipur on 17/11/22 physically, but the same was refused to be accepted by the learned court. Finding no other alternative, the petitioner sent the restoration petition by speed post with AD on the very same day, which was received by the learned labor court on 18/11/22. This is my short grievance, your lords. And thereafter,
17,
well,
Mr. Mishra,
Fine,
17/11, you
correct,
Alice,
for
it has-
recalling that order.
it has been refused to be accepted.
Physically, it was refused to be accepted.
Ah.
That is why I have sent it by speed post, your lordship,
Speed
which is
post can-
accepted the next day.
Speed post is
Yes, lordship. Annexer 6, your lordship, may kindly have a reliance.
page
Page, sorry. Yes, 64, your lordship. 64 is my restoration miscase. And your lordship, 71 is the endorsement.
Page 54,
64, 64,
64.
yes.
No, 64 is the application.
Application, your lordship.
So where
71, your
registered?
lordship, is the endorsement. 71.
71.
71 is the endorsement, your lordship. Your lordship finds the date 18/11/22. And this is within 1 month of the notification of the award, your lordship.
All right, in the events such application. Had this.
My lord, I am-
Yes, sir.
My lord, I am appearing for the
Ah.
workman,
Yes,
the
yes,
opposite
yeah.
pen number 2.
You
my
are
lord.
for?
Workman opposite pen number 2, my lord.
Right.
Your lordship have a glance the page 57, internal page 9, my lord. The London trial court observed that whether they have not expertise,
They have?
not no order of expertise. Again, the
No, we are not
Right.
dealing that now.
my lord,
His simple prayer is
my lord,
that on some grievance,
my lord.
they have brought an application before the authority for their consideration, for
Mhm.
its consideration.
My lord.
Now, there should be a logical end to that application or not?
Yes.
That has been explained in a impure judgment, my lord. The London trial court explained.
He-
They have appeared and filed
Oh,
judgment.
impugn
My-
judgment. How
my
can
son.
he explain the application filed subsequently?
My lord, there is they have not produced any order regarding expertise against them, my lord.
Again, you are not understanding
My lord,
probably.
sorry,
us.
my lord, sorry, no, my lord, sorry, my lord.
What we said? We said
My lord,
there is some award.
my lord,
They have a grievance that they remained expertise.
my lord,
They have a grievance.
Ma'am.
We don't say, we
Ma'am.
don't accept even that.
my lord,
On that footing, maybe they have filed some sort of application.
my lord,
Application not being received, it has been sent through registered post.
my lord,
Registered endorsement is there.
my lord,
Should the labor court pass some order or not?
Yes.
my lord,
We are not on merit. You are arguing
Ma'am.
on merit.
my lord.
You argue there, you go
Ma'am.
there. You have now come to know that such an application is pending. You go there and argue. Make your submission, sir. It is not an expiry order. Therefore, it can't be recalled.
Ma'am. My lord,
We are not entering, we are not expressing any opinion at this stage
Right.
even.
my lord. My only grievance is the time may be fixed there.
That you
Yes,
can
yes, fine.
say,
That's
My
right.
lord.
That's right.
but you are arguing something
Ma'am.
surprise.
In fact, there is
At
no
the
order. My
submission of Shri Narendra Kishore Mishra, senior advocate, along with Junior
Nitish.
Mishra, no?
Nitish, your lordship.
Appearing for the management, and Shri Digambar Sethi
No, no,
appearing for the workman, copy number
yes,
2,
correct.
and the state council, who is the state council here? You are there, Mr. Bose, learned AG. Read petition involve the following prayers. Taking this court to the pleadings in the writ application through para 18 and 19, together with the materials available at page 65, Danister 6, page 64, and a registered post receipt, page 71, 71, 72, Shri Mishra contents being agreed in the manner of disposal of the award dated 20th-9/22, read with order dated 24/8/22, passed by the presiding officer, Labour Court, Jaipur, in ID case number 2 of 2014. The management petitioner has brought a restoration case claimed to have been filed before the Labour Court on 27/11,
1711.
17/11/22. It is alleged, through the pleading, it is also alleged that the Labour Court Jaipur, on instant refusal to accept such application, management petitioner has been compelled to send such application by the registered post. It is further alleged, in spite of receipt of such petition by the Labour Court Jaipur, there has been no hearing nor any order on the application filed therein. Counsel, it is in this circumstance, Sri Mishra claims, once an application has been brought to the board of the authority, there should be a logical end to the same. Counsel Sri Sethi, learned counsel appearing for the workmen, on the other hand, attempted to take this court to the discussions in the award involved herein and attempted to contend that award in fact is not an expertise award. For the innocuous request involved herein and page 71 establishing sending of the petition, prima facie establishing sending of the application at annexure 6 by the management, this court, without expression of opinion on the merit involving such petition, simply direct with an observation that once an application has come to the board of the competent authority or court, there should be logical end to such application. This court direct the Labour Court in the event it is Labour Court Jaipur, it is in receipt of any such application, the application should be given a lawful disposal. After giving opportunity to the workmen, opposite party herein, and by completing such proceeding at least within a period of 4 months from the
Yes.
date of communication of order. Since OP number 2, counsel for OP number 2 undertakes on behalf of the OP number 2 for appearing before the Labour Court, in the event any such application is pending at its end, this court permit the workmen to find if any such application is pending before the Labour Court, and in such event will make its appearance, his appearance. It one workman,
One,
one.
yes.
his
Yeah.
appearance.
Number 2.
And in such event, the workman will also will make its appearance at least within 10 days of the order. Okay. If pursuant to appearance of the workman may also be permitted at least 10 days time to bring its objection to the entertainability of the application involved in it. Hello? Okay, and the matter shall be given a lawful disposal after involvement of parties within 4 months.
Okay, 4 months.
All
I
right.
have a small prayer, Your Lordship. IA had filed because they are now execution which is pending. That is continuing from very
Mr.
short date.
Mishra, we
My
should
lordship.
not advise you.
No, I'm not saying the stopping it.
expression of any opinion would lekhicha on the merit of the award or in this application even.
Yes.
In the application involved here in it, na seta corrected ho mate dabam dekhi.
Your Lordship, only I was drawing your lines to
That- Mr.
again.
Mishra,
No, no,
you
till
know- you know there are ways and means.
Yes,
Why
yes,
are you insisting court to pass some order which is not wanted here?
only protection till that date, Your Lordship, till
Sorry.
it is finished.
Sorry,
Only. Because I'll take steps, Your Lordship. I'll take steps.
see when you filed the application,
What again?
when you
November,
filed that
November, Your Lordship.
November,
Yes.
we are in what month?
Your Lordship, I had filed it in
So
May, Your
therefore,
Lordship.
7
May.
months have gone in
May.
the meantime. We don't know what is the
That-
stage there.
Yes.
Yes,
Because-
if you would have come within 15 days, things is different.
And we were thinking that
Are
you'll be
15
entertaining and also
days,
issuing
2
notice, Your Lordship.
କାହିଁ ଆପଣ ଯୋଉ ମାସ ମାସ ଧରି କାହିଁ ଅପେକ୍ଷା
No,
କରିବେ?
no, the whole thing is
ତାମାନେ
that,
ଲୟର ପ୍ରତି ମାସରେ ଯାଉଛି ରେଜିଷ୍ଟର ହେଲା କି ନାଇଁ ଦେଖୁଛି
no, no, it's not
ଆଉ
that way.
ଅପେକ୍ଷା କରୁଛି କାଳେ ହବ କି
Not that way.
ଫିସ୍ ଚାଲିଛି
ସେଠି ଗୋଟେ ଅସୁବିଧା
Fees
ହଉଛି that we are
ଚାଲିଛି।
not getting the certified copies
please
also. That is
please
also
less
correct.
talk is
To our
better,
knowledge.
you know the
Yes.
ways and
Yes.
means, so
ठीक है. Obliged.
Item number 3,
yes, item 3 minimum wages appeal ଅଛି ନା, you have come against appeal order, who is there for the petitioner? Yes, Rasminaran Patnaik, Mr. Patnaik, you are there.
No,
Why
this
are you
is not an
hesitating?
appeal, my lord.
Huh?
This is not an appeal.
No, this is against an appeal.
No, it is a minimum wages act. That's why A is there. MWA.
Okay, so no appeal provision there.
No. Section 20, an order under,
You are for the management.
I am for the management. I am for the contractor actually.
That's right.
There was a contract and
So what is the award there?
the
Annexure?
that is
Annexure
annexure 5, it starts from page 23, my lord.
22.
23.
Where is the original?
Original I have filed authenticated, my lord.
Where is that?
That is,
We don't find in our record.
that is, the noting
Oh,
is
yes,
there.
all right,
Noting
sorry, it
there.
is there. In a memo you have filed
Yes, my
subsequently.
lord. Subsequently.
Okay, now come to the award part,
Yes, my lord.
the direction part.
Yes. It is at page 25, my lord.
Yes, come to order portion.
That the claim application filed by the applicant is allowed, I hereby direct the opposite party number 1 to pay rupees 5,53,280 to the concerned 32 workers through their bank accounts within 30 days from the date of receipt of this order, or in case the employees are not available traceable, the opposite party 1 should deposit the above amount within this period with this authority by way of a demand draft in favor of the Assistant Labor Commissioner Central payable at Bhubaneswar for disbursement to the concerned workers through the applicant. Further, opposite
What
party
is the
number
ground of challenge? What is it is
My lord,
optional, it's a composite amount
Yes, my lord.
to be
Period-
entitled to
period-
32 workers.
Yes, my lord. Period of less wages as per the order is from 2000, it is in 2011 to 2020.
No,
12, my
from
lord.
1/12/10 to 31/7/11.
Yes, my lord.
Hmm.
That is 12 years back.
12 years back.
My lord.
All right, what is the law then if somebody comes to court late?
Lordship may kindly see, I am not.
What is the
Section-
law on this
Section
subject?
20.
If somebody in
Section-
industrial disputes,
Section-
the Supreme Court has attended to such question. If somebody comes
Minimum-
in,
In minimum wages, I am placing section 20,
minimum wages act.
subsection 2,
Parantu.
proviso 1.
Subsection
20 subsection 2 proviso 1.
My lord.
provided
हाँ हाँ जी sir. Just 1 minute. हाँ सेटा पढ़ंतु पूरा टूरु पढ़ंतु.
where an employee has any claim of the nature referred to in subsection 1, the employee himself or any legal practitioner or any official of a registered trade union authorized in writing to act on his behalf, or any inspector, in this case the inspector has a report,
ठीक है.
or any person acting with the permission of the authority appointed under subsection 1 may apply to such authority for a direction under subsection 3. Provided that every such application shall be presented within 6 months from the date on which the minimum wages became payable.
When the application was made? When the application was made?
As per the order, my lord, it is within the time. But I received the notice in 2012, my
No,
lord.
so that's not the requirement.
2022, my lord.
That's not the requirement.
My lord.
Requirement is somebody is to bring an application. Filing is essential.
Lordship, may kindly.
That also appeals to common sense.
After 11 years, I am noticed, my lord.
Oh, sorry. Your notice is not material here.
Section
Law, you are placing a law.
Yes, yes, my lord.
Provision of law
Right.
says one is required to bring an application within.
Yes, my lord. Lordship may also
So
kindly
notice after
go
12
behind
years,
the
whenever
intention of the law, my
officers
lord.
are not there, notice not being sufficient, you might have refused
No,
all
no.
these things.
No, my lord. The notice
So
was
Patnaik,
received.
then if jodi it becomes ex parte,
No, my lord. It
so
was
ex parte then 24 to
Is-
1 proviso is not applicable.
no.
So that is not an argument to be made.
No,
It appeals to
my-
common sense. It's a question of filing.
Yes, my lord.
So if
No, that's
at
the
all,
only question.
if you
The-
if at all
the-
as fell from
the
my if
adjudication-
you have any case regarding filing, then you show it here.
That's the only argument.
No, my lord.
Other
Other.
argument.
I am a contractor, my lord. I have annexed the contract also.
Hmm.
The management for whom I have been employed to provide personnel, my lord. They have not paid that amount, my lord. The
That's a
VDA or
Mr. Patnaik, that's a different issue. That's a different issue. Workmen should not suffer
no,
for misconduct by the principal employer. And why are you sleeping? Now, as you said, it's a 12 years stale matter.
yes, my lord.
Okay, you knew that these people will be entitled to that.
No, my lord.
This is less payment.
Actually, what
This
happened?
is less payment.
No,
So what action you have
I'm a-
taken against the management?
I'm a permitted for
Yeah.
a moment, my lord. This notification of enhancement of minimum labor comes after the notification made by the government, my lord. So the
Oh,
management,
Obviously, every notification comes 1 year
Management-
after or 6 months after. That's a known factor.
yes, my lord.
That's a
Then
known factor. Therefore,
uh,
as per contract,
That-
any labor enhancement,
My-
the benefit should go to the worker.
my contract ended by then, my lord.
Maybe. Maybe.
That amount should
Therefore,
have been
now
paid by the
you
first
could have-
management, my
Mr.
lord.
Patnaik, you
Yes,
should
ma'am.
have been benevolent enough,
Yes.
even on receipt of the application, to put a claim before the management. Sir, here is a claim based on a notification.
We didn't-
Workers should not suffer.
We
What
didn't-
action?
We
Now
have the
come,
whole
now
knowledge,
come
ma'am.
to your response. Now come to your response in the proceeding.
Yes, ma'am.
Where have you stated that?
That has not been reflected, ma'am.
ଆଉ ତାହେଲେ କାହିଁକି argue କରୁଛନ୍ତି? This is appeal. Please. We have to understand our limitations.
Yes, my lord.
So therefore, why you advance a question, a submission which is not here or there?
My lord,
Had this.
my only
Sorry, Mr.
submission is
Patnaik, we can't
the-
waste our time.
the lordship may kindly go into the intention of the legislation, my lord.
Had this
The 6
submission
months
of
of,
council.
6 months.
Please. We find 2 grounds, we are answering on that. Had Sri Patnaik learned counsel for the petitioner, the immediate employer, the contractor undisputed. We have had the counsel on the question of entertainability of the application. Undisputedly, read petition involves a challenge to the order oblique award passed by the Regional Labour Commissioner C. Rautala in application number MWA 51/2022 in exercise of power under the Minimum Wages Act 1948. Background involving the case. The workmen involving the contract between the petitioner and the principal employer were undisputedly supplied by the immediate employer. The workmen involved put up an application before the competent authority claiming.
Pardon, my lord. The inspector applied, not the workman.
Okay, made a complaint to the inspector. Made a complaint.
Factually, are you sure? Because there is a lot of discrepancy that there was no complaint. Can you record your submission?
Pardon, my
Faithfully.
lord. Pardon, my lord.
ଆପଣ କହୁଛନ୍ତି ନା ସେମାନେ ପିଟିସନ ଦେଇ ନଥିଲେ.
No, workman then.
Are you sure of that instruction?
Yes, my lord. The inspector,
କେମିତି ଜାଣିଲେ?
inspector
page
verified the records.
Complaint ହେଲେ ଶୁଣନ୍ତୁ first complaint ଟା inspector କୁ ହିଁ ଯାଏ.
Inspector verified the records and
Verified record.
he made-
Okay,
he
that
made
is also a possibility. Okay, like the inspector concerned, put the applicant, workman put up application to category. In exercise of power, the inspector under section 19 of the MW Act 1948 found there has been short payment, less payment of wages of the 32 workers on the register of the immediate work employer. And the shortfall in the payment of wages appeared to be for the period from 1/12/2010 to 31/7/2011. It is on the basis of the report a suo motu proceeding was initiated by the competent authority. Parties were hired, and finally there is direction by way of order directing the opposite party number 1 managing director Messrs. Excel Security so and so the petitioner herein to pay a sum of rupees 5,53,280 to the concerned 32 workmen through their bank accounts within 30 days with further directions therein. The immediate employer bringing in the litigation herein advances two grounds in his opposition to the impugned order herein. Ground number 1, when the statute says, statute for the provision, section 22, section 20 bracket 2,
Proviso 1.
proviso, first proviso of the Minimum Wages Act 1948 says an application has to be brought within 6 months. While not disputing that the application was brought within 6 months of the dues, the Patnaik, however, claims the immediate employer being noticed after 12 years, notice of the proceeding after
11 years.
Being noticed after 12 years of the institution of the proceeding, the entertainment of the proceeding is affected by the provision at section 22, section 20 bracket 2, first proviso. Second limb of argument of Sri Patnaik appears to be there has been no payment of the additional wages by the principal employer, and for such notifications comes in after expire of the contract period of contract. The petitioner herein is not obliged to make such payment. Considering the points asked in entertaining the writ application, this court, attending to the first question, first leave of argument, taken note herein above, finds provision section 20 bracket 2 first proviso reads as follows. It is 20 re claims boli lekhibo, hala 20 claims, then 2 taku type karibo and the first proviso type karibo. Okay. Dita ka proviso lekho. So dita ka proviso type karo. Proviso 1 and 2 dita 20 डॉट देखिए एकदम छकी 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 दिया हुए सब दे टाइप करे आरंभ करो हां प्रोफाइल अकाउंट लिखा हुआ है सेक्शन में careful. Okay, now reading the aforesaid provision, this court find for the statutory arrangement under the Minimum Wages Act 1948, the only requirement at the instance of workmen or only requirement in putting up a claim of less payment appears to be such application should be presented within 6 months from the date on which the minimum wages became payable. This court here in the entire reading of the pleadings and the submission of learned counsel Sri Patnaik finds there is no dispute that the application here has been application at the instance of the the report convert taken to be an application on the under section 20 of the Act appears to have been submitted within 6 months of the from the date of the date there. As we find from the date of minimum wages became payable, as we find from the application from the record, the application was filed on the report. The report was brought on and the report under section 20 of the competent authority was brought on 29/2/2012. There is no denial also. Sorry, Sri Patnaik also doesn't deny that the application or the cause of action arose only after the notification in the enhancement of minimum wages surfaced. It is in this circumstance this court find there has been right consideration on the entertainability of the application. And there is no scope for entertaining the writ application on this ground. Coming to the second ground available herein, raised herein, this court find even though the immediate employer was served, even assuming that the immediate employer was served the notice involving the matter after 11 years. But there has been fullest opportunity to the immediate employer to contest the property, and there has been no ground available on behalf of the immediate employer to decline the claim involved therein. As we have already observed, the application was in time. Service of copy after lapse of long time doesn't get affected by the provision of law. Taken note herein above. On the question of management did not reimburse the amount as directed by to the immediate employer as directed by as computed by the competent authority, this court observed for the clear provision in the Minimum Wages Act and the provisions made through enhanced notifications. Law has been already well settled, observing it is the responsibility of the workman, of the immediate employer to first clear the amount, and on an application on such outstanding being placed before the management, there would have been no difficulty on the part of the principal employer, the real management, in reimbursing the same. We don't find the petitioner is able to satisfy that there has been already payment and the payment of the amount involved, and the principal employer is not making over the use to the contractor on this account. Let this court find there is no substance in both the grounds taken herein above. As a consequence, this court find there is no ground to entertain the admit even the writ application. The direction for the northern leg 3% lagibo that they have to observe on the The writ petition does stand dismissed at the stage of admission itself.
Our apprehension. My
Please, your lordship. I beg to appear on behalf of the petitioner Utkal Chamber of Commerce.
Pardon?
I beg to appear on behalf of the petitioner Utkal Chamber of Commerce.
Kindly speak to the microphone. Just adjust it to your. Yes.
Lord, I beg to appear on behalf of the petitioner Utkal Chamber of Commerce. The petitioner.
So your OP number?
This is I'm for the petitioner.
Oh, you are for the petitioner.
That's right.
All right.
But we have challenged the notification.
Your
dated,
name is not there. Your name is not there.
Sitesh Mukherjee, Lord, my name is Sitesh.
No, your name is Mr. Mukherjee. Your name is not appearing in the Vokalatnama. Are you a senior counsel?
No, but I come from Delhi. That is why.
You come from Delhi. It's all right. But what do we find your power to argue?
The local counsel, Mr.
There is no appearance memo today for today even. What your assistant counsel is doing, we can't hear without a. You are not a senior counsel, so that you can straightway stand and argue.
I just said, therefore, I beg to appear, Lord. Of course, it
No,
is
then
obviously
you
lost
first
in
fight
pleasure.
thereafter.
I will file a Wakalatnama in the course of the day, if your
In the
lordship.
course of you first fight.
And a
thereafter.
memo immediately after.
Wakalatnama is not necessary. He has to file a memo authorizing.
Memo of appearance.
He
He
can
has
file
to
a
take
memo.
care of that.
He can file a memo.
So we bring it on tomorrow.
Lord,
Your name is not there,
Very well.
but what is there? is
right now,
what?
we will file the memo, if your lordship.
Where is that? Bring it.
Your lordship. Lordship, pass.
Wakalatnama is ready with court fee,
Memo.
or the appearance memo is
Memo.
ready with stamps.
Memo, we will.
Oh, sorry, you can't file just a memo. Sorry. Because party may come and say that we have not engaged any such counsel. Regular is tomorrow. Yes, there is no appearance on the counsel appearing to be claiming to argue on behalf of the petitioner.
But the
Say Mukherjee. Yes, sir. Please, your full name?
Sitesh Mukherjee.
Sitesh.
Yes.
All right. Let there be filing of memo, appearance memo at least, authorizing counsel outside the Bhokalatnama to place the case. List this matter tomorrow,
If your lordship.
along with any appearance, if any.
I am grateful that your lordship are taking it tomorrow, but if I could request, my lord, that your lordship hear it, I will file it right now, my lord. I have come from Delhi, my lord.
No.
It will take 5 minutes, my lord. It is already covered by earlier
Okay,
notice.
all
of
right, you
super-
wait, bring it, bring it.
Yes, I am so
You wait,
grateful.
we are passing it over.
I am so grateful, my lord. I am deeply obliged.
Item 5,
Yes, local council, sir, did you not know the procedure? Why you have harassed the council from Delhi?
Apology, your lordship.
And he is a council in Delhi, he must be knowing these practice.
Your lordship.
So
Apology,
you
your
made
lordship.
to suffer the court even.
I am so Your sorry.
We have
my lord.
wasted time for
I-
5 minutes.
I am very
unnecessary.
sorry.
Please,
Malak,
please
can we
come
take
with-
it tomorrow?
No, we don't entertain any outside council, even local council. I don't say outside, any council other than the Bhokalatnama.
We'll file the memo right away. We'll call you.
Next,
Malak,
file.
can we take it? Malak, can we take it again tomorrow? In this case, I am appealing for the opposition one.
File.
One. Can we take it up tomorrow?
Oh, in item 4.
Yes,
So, I'm convinced Karantu, he has some difficulty.
because I have some,
You agree for a date.
tomorrow.
Arre,
No, no,
tomorrow he
he's
has
saying,
objection.
the problem is that
He is
in fact-
requesting for passing it over.
no, he's saying he has another matter.
He has another
I'm-
matter.
So you decide amongst yourself when to fix it.
Tell,
So that-
tell the date, tell the date. Give a consent date. You
Tomorrow,
say tomorrow, he objects tomorrow.
Objecting that I'm just.
There's no point in asking for tomorrow, Mr.
I take
Sotaki.
it around 12.
Oh, you talk with him and give a date. We are passing it over.
Yes, possibly, Malak, can I take it about 12:15? I'll take that.
Oh, you are submitting, Mr.
No,
Sotaki.
Upon time, right?
Suddenly there is another, other matters are there.
Yes.
Also, personal appearance and chamber matters.
Okay.
So
You talk with him and give a date. ଏ କାଚରେ କଣଟା ଶୁଭିବ ମ କଥା ହଉଛନ୍ତି item 5
my lord, this is matter relating to minimum wages act, my lord. Your lordship, I pray for time, though I have not prepared fully, my lord.
you are not prepared fully.
My lord,
ଫାଇଲ କଲେ କଣ ଆପଣ ଫାଇଲ କରିନାହାନ୍ତି
ମୁଁ ଫାଇଲ କରିଛି।
ଆଉ ପ୍ରିପେୟାର ହେଇନାହାନ୍ତି କହୁଛନ୍ତି ଫାଇଲିଂ ପରେ
ଟିକେ ଆଜ୍ଞା ଲ ପଏଣ୍ଟ ଟା ଦେଖିବି ନେକ୍ସଟ ୱିକ ର ହବ।
ଓ ୱିଦାଉଟ୍ ଏକ୍ସାମିନେସନ ଅଫ ଲ ପଏଣ୍ଟ ଆପଣ
ଦେଖିଛି
ଫାଇଲ
ଆଜ୍ଞା,
କରିଦେଲେ
ଦେଖିଛି ହଜୁର, ଲେଖିଛି ବି, କାଳେ ଆଉ କିଛି ବାହାରିବ।
your application probably having a serious defect. Where is your certified copy?
Certified copy I have not annexed.
Huh?
I have not annexed certified copy.
You have not annexed, then
My
this is
lord.
not entertainable. Why are you not asking on that ground alone? କେବେ ଫାଇଲ କରିବେ କାହିଁକି ଆପଣ ଫାଇଲ କରିଦେଲେ କେମିତି where is the original the supplied copy at least ଫାଇଲ ଭିତରେ ଅଛି କି ଦେଖନ୍ତୁ
ନାଇଁ ଫାଇଲ ଭିତରେ ନାହିଁ।
ଆଉ ଫାଇଲ କରିଦେଲେ କାହିଁକି
ଗଲା କୁଆଡେ?
କଣ ପାଇଁ ଫାଇଲ କରିଦଉଛନ୍ତି ଆମେ every day we are finding this difficulty. ପ୍ରିପେୟାର ହେଇନାହାନ୍ତି ଲ ପଏଣ୍ଟରେ ସାର୍ଟିଫାଏଡ କପି କିମ୍ବା ଅଥେଣ୍ଟିକେଟେଡ କପି ନାହିଁ କାହିଁ ଭୁସ କିନା ଆସିକି ହାଇକୋର୍ଟରେ ଫାଇଲ ହେଇଯାଉଛି କେସ୍ ୱିଡ୍ର କରିଦିଅନ୍ତୁ ଫୁଲ କରିବେ
ନେକ୍ସଟ ୱିକ
ହଁ।
ରହୁ ହଜୁର, ମୁଁ କରିଦେବି ଏ ଭିତରେ।
But next week onwards, we make it clear to the bar. Wherever certified copies will not be there, authenticated copies will not be there, we'll outrightly dismissing the matters. Will not give such opportunity. That is mandate. Place the matter on next Monday. In the meantime, then let there be filing of at least the authenticated, the communicated copy of the order, impugned order involved therein. Yes. It is made clear in the event there is no filing of authenticated copy or certified copy of Annexure 2 by Friday. The matter will be dismissed without further reference to bench. However, with liberty to bring a fresh filing along with the certified copy.
Problem.
Yes, कौन डेट है कि आइटम 4 रे ना बाहर पळेले बुझियो बोली जणे आछन देखा होछ ऑल आइडियास नेक्स्ट केस
अब item टा से
हां सब सेम ओइटा सब एकदम Your
Your
also
lordship
same.
called
Yes,
for
what is the consent date?
Next Monday, subject to your lordship's pleasure. my lord.
Pardon?
Next Monday.
Next Monday.
Subject to your lordship's pleasure.
No, next Monday we don't have any difficulty. Yes,
I'm grateful.
next Monday. In the meantime, you ask your local council to file, bring your power.
Yes.
Okay.
May I just submit that this is for issuance of notice only?
Pardon?
This is only for issuance of notice, first admission, my lord, notice. And my lord, in a previous challenge, notice has already been issued.
If notice is already issued, then it will be had
My
only.
lord, this is the second notification. The previous year's notification,
Okay,
notice
let
has, we
us
have
see on
challenged,
Monday.
notice has
Let
been
us see
issued.
on Monday.
So, my lord, only on his submission also your
Let
lordship
us
can
see on
issue
Monday. In the meantime, soft copy, ask your
notice.
local
Very well, my
council
lord.
to soft copy.
Sorry for wasting your lordship's time. I'm deeply
Yes.
grateful for the indulgence.
Item 6. For orders, item 6.
My lord, item 6, I will take fresh step, my lord. With the correct address, my lord.
Insufficient address, okay, no, notice in limitation matter return. On observation. Unserved with a postal remark, insufficient address, counsel for the petitioner 6. Kete din time?
My lord, within a week, my lord.
Okay, 6 at least a week time to take fresh steps in the matter of limitation on the opposite party herein with correct address. Yes. आप फाइल कर देबे हमें रजिस्ट्री को डायरेक्शन दे दो
My lord.
in the event correct address fresh requisites are filed sorry fresh correct address of the respondent is filed registry may do well in issuing notice on utilization of the copy of limitation petition return unserved fixing
Okay.
short returnable date and matter be listed after appearance of the party.
Obliged.
Yes.
Item 7.
May notice was issued but not returned.
Yes, court master special notice la
Again.
parties are there. Achha. Okay, all right. Khali seti.
May I please your lordship?
Neither AD nor unserved
Yes, sir.
notice received from sole respondent, none yet appeared. Kepe, what was the date of appearance fixed?
On 15/5, LCR was called for and notice was issued. But
Uh-huh.
on 15th May, notice was issued and
No,
LCR
notice
was
was
called.
issued.
But there is no specific date to your lordship.
हाँ सही कहता हूँ date of appearance टा notice टा देखिले. Okay, 3/7 was the date of appearance.
Yes, sir.
Okay, all right, all right. Like notice was issued on the respondent. Postal tracking report shows item is not delivered. তাহলে fresh notice নেবে? हाँ, outside immediate. All right, place this matter 7 days after. Registry is directed to give a posted us with updated report on the service of notice on the respondent. Any interim order there?
No, your lordship. Only
All
LCR
right.
was called for. Admitted.
Next Monday ଆସିବ ନା? Repetition hearing ହେଇପାରିବନି ଆଉ ଅବିକା.
Sir.
Repetition hearing ହେଇପାରିବନି will be rising shortly.
12:25 ରେ ଆପଣ 12:25 your lordship will to rise.
Yes, all right. ଦେଖିବା 8 ଟା କାଲିକି ଆସିବ. Tomorrow actually account.
Day after tomorrow, my lord.
Day after tomorrow ହେଇପାରେ.
Day after tomorrow.
ଆଜ୍ଞା.
All right, on the request of both the councils. Place this matter day after tomorrow. Is କୌଣସି matrimonial case ରେ ହେଇଥିଲା କି direction କିଛି? ଏଗୁଡା ସବୁ ପୁଣି reappear କରୁଥିବ।
Item 9,
Made please your lordship.
Mediation report.
9 ରେ successful ହେଲେ?
No, my lord, mediation failed, report is there before your
Oh,
lordship.
that is a failure report.
My lord, failure report.
Then argument will be advanced.
My lord,
Argument will be advanced.
my lord. There is a separation since 2012 till date, absolute separation and admitted. Allegation, counter allegation that I have deserted or she has deserted.
What was the application involved?
The appellant before your lordship is the husband, petitioner. He has filed a petition for divorce.
Husband filed a petition.
For divorce in the court below.
Rejected. Rejected.
Yes, my lord. The wife filed the WS cum counterclaim for restitution. That has been allowed. My divorce has been rejected and the restitution has been.
Divorce on what ground?
Divorce on the ground of cruelty, your lordship.
Cruelty only.
Cruelty.
What was the time gap in separation between them?
Now it is 12 years.
Please.
At the time of filing.
No, you must understand what is the query.
My lord.
What is the query?
The time gap at the time of filing of the petition.
No. Time gap at the time of separation. Marriage date kete, separation kete.
Marriage date 5/2/2010.
5/2/2010.
2010.
Yes, when the separation took place.
22/9/2012.
এটা 5/12/2010.
5/2.
5/2/2010.
My lord. 5/2/2010.
Separation
on 22/9/2012. And since that date, the separation continues till now.
Separation is to 2012.
22/9/2012.
So hardly two and a half years.
My lord.
Our opinion is 2.5 years is not sufficient enough to come to hold that there is irretrievable breakdown. Can you get a judgment to support your case?
My lord.
Bring a judgment that this period, even thereafter, there is lot of development. She is there, you are here, and now you want to have luxury by getting down an order of divorce.
My lord.
କଣ କରୁଛନ୍ତି ଆପଣ? Staying separate for nearly 12 years, 11 years. Showing his readiness to give at least a sum of rupees 10 lakhs to the wife respondent. In this circumstance, this court direct the husband to file an affidavit showing his readiness to the aforesaid amount. If possible, may enclose showing the readiness of release this matter on next Monday. Who appears for the wife? Mr. S. Patnaik. There is a lot of counsel, S. Patnaik, A. Barik, S. Mahathi. There is no appearance on behalf of the respondent when the matter is called. Release this matter on Monday again with indication of the counsel appearing for both sides along with the affidavit if any. You intimate in the meantime to Mr. Patnaik.
My lord.
And serve a copy. Or his counsel. You serve a copy, is affidavit file on service of copy of the same on the counsel for respondent. Okay. Yes, we are rising. in a division bench.
my lords. And
But it is not a matter for division bench.
lordship,
What is your challenge here?
lords, we have challenged an order under section 15A of the OSS Act. Lordship, that is at annexure number 5,
15A.
my lords. 15A.
So
There was a collector had given a notice, given the information to the commissioner that certain lands which are government land in the final ROR had been recorded in the name of two private persons.
yes.
Thereafter, a 15A case was initiated, your lordship. And that
When-
15A,
when that order was passed,
my lords,
15A order was passed when?
15A, the first order was passed in 15/10/1991. Then they had come into the High Court challenging that in a writ petition. The matter was remanded back again, and then this remanded
Final order came when?
that came, your lordship, on 25/10/2011.
So again, you're filing writ after so many.
There is a
years.
delay of 6 years, lordship. We admit that, but however,
Delay
your
of 6 years, non-admission takes the delay to 13 years now.
lordship may kindly have a glance at the order, because here there is a strict allegation of fraud. Is there, your lordship? Secondly, the 15A order that has been passed on the basis of a completely void order, your lordship.
Void order.
My lords, that order is under section 21(2) of the OSS Act, your lordship, where the assistant settlement officer has the power to suo motu revise the rent of a particular plot. Here, what has happened, your lordship, is that power, which is to be exercised only before the final settlement roll is published under section 22, he has exercised that power after the settlement.
Answer on one question.
Lordship.
State usually opposes admission of every matter. So why should state come as a litigant?
Lordship, but here your lordship's judgment is also there.
State is opposing all matters or not?
Lordship, we oppose, lordship.
So why should state come as a litigant?
No, but here your lordship,
Issue notice on the question.
my lords.
Well, question of limitation, if raised, shall be considered at the time of final hearing.
Lordship.
Question of limitation, if raised, shall be considered at the time of final hearing. There is no miscase.
Miscase we have filed, lordship.
Okay, all right. If it is observed, miscase, in the event the impugned order dated 25/10/2011 annexure 5 has not been worked out as of now, same may not be given effect to.
May only pray,
Leave of the court.
may only pray, let there not be any creation of third party rights, your lordship.
No, if it is not worked out, I have protected you.
My
If
lords.
it is not worked out, it will not be worked out without leave of the court.
Lordship.
That's the interim order. Mr. Ponda, Mr. Ghosh, Mr. Ponda, Mr. SAHOO, probably you have asked him to stand in this matter.
Item number 2.
All right.
So may I please, lordship, your last document, lordship directed my lord friend to take instruction about payment, my lord. Since the petitioner completed the work, but no payment has been made.
Any instruction?
Twice we
Why
have
there is
intimated.
delay?
No, question is not twice we have intimated, though we have not received the instruction that I found. There is-
Mic down, girl.
I found annexure 4.
Hmm.
Here what has happened, but the work order was issued by the concerned Sarpanch. He has executed the work. Now bill has been submitted with counter signature of the junior engineer, assistant engineer, everyone. Now the PEO, that is Panchayat Executive Officer. Panchayat, no, he's Panchayat Executive Officer, Panchayat Extension, GPE, so that is GPEO. This is PEO. Panchayat Extension Officer, he writes that this sanction comes from the central government. As of now, they have not received this sanction. But I fail to understand, if sanction was not there, money has not been sanctioned for a particular purpose. How is that the work?
How the work has been conducted
Exactly.
without sanction?
Exactly,
Sanction
exactly.
there.
Lord,
You
therefore,
file a counter affidavit.
I will file a counter. Your lordship also issue notice to that Panchayat, Honorable Sarpanch. He is
Panchayat,
all,
what happened to Panchayat?
they have been made party, my lord.
They have been made party,
Yes,
but
yes.
they have not been issued notice.
ना issue है ना notice. That खाली instruction में पठी.
Okay, on instructions, we go from
No instruction, my lord, actually.
last occasion, while directing serving of copy on the state council was also directed to obtain instruction onto the delayed action involving the release of payment in favor of the petitioner. under the allegation that petitioner has completed the work assigned long since, and there has been no payment for his work already completed. She goes, Learned State Council on instruction submits
Not on instruction, on referring to the document. Annexure 4.
to Annexure 4.
No bill has been submitted.
Annexure 4 is
That copy he has received.
Hmm.
So this is as to,
okay, from
this is
the-
quite astonishing.
from the development through Annexure 4. କିନ୍ତୁ ସେ ତ ଲେଖୁଛି ମୁଁ ଅର୍ଥ ପେମେଣ୍ଟ ପାଇ ନାହିଁ ବୋଲି।
हाँ, नहीं, central
So,
say,
PO lecture.
आज्ञा, PO
Okay,
कर
where
जो
the
same
The
PO
work also
himself
done by the
indicates
PO, my lord. The work.
that is
ना ना
even
ना
not
जितेंद्र
the
कुमार
receipt
जेना
of the amount involved. She goes in the circumstance submits, there is doubt whether there was financial concurrence on the construction involved or not. This could direct the opposite parties to bring appropriate affidavit, creating hurdle in the release of the amount involving the petitioner. Okay, at the same time, this could also direct notice to the other contesting party like OP number
5.
5
yes.
requisites as undertaken be filed by tomorrow. Matter be placed immediately after appearance of the surplus. Yes. Counter if any be brought in the meantime.
Item 3.
My pleasure, Your Lordship.
Yeah.
Challenging the order passed at Annexure 2, my lord, I filed the writ petition. Here, what happened, my lords? The present petitioner, he is the purchaser from opposite party number 6 to 8. Initially, the land belongs
That's
to.
right, but this order is of 2002.
2000, my lords, I came into picture in 2022.
You came to?
Picture in 2022. I purchased the land. My case is that I obtained the order sheet. No notice was issued to the Kabir Muhammad, my lords.
No notice was issued to?
Kabir Muhammad, the original landowner. Land belongs
Then
to.
why are you not bringing Sabir Muhammad?
Pardon, my lords?
Why are you not bringing Kabir Muhammad?
Kabir Muhammad is dead, because thereafter this.
He is a party, opposite party 6 there.
He is dead. Thereafter the property came into the hands of opposite party number 6
He
to 8.
died when?
Much before, my lords, because I purchased the land in 2022 from opposite party
So
number
he
6 to 8.
died when?
Sometimes that instruction.
How do you claim that he was not noticed?
Because I have annexed, my lords, your lord, I have given a representation before the concerned officer, my lord, consultation officer. That has not been considered, my lords.
Pardon?
I submitted a petition before the consultation officer, my lords, that the 3 persons, your lordship may come to Annexure 4 series, my lords.
Yes, page?
Page 35, my lords. Last page. Last but one, sorry.
Yes.
Your lordship, there are 7 opposite parties. It starts from page 34. Boita Malik, SCR Chandwali, Saleh Muhammad. I am in opposite party number 6, my lords. Sheikh Kabir Muhammad.
Annexure 5 is the order sheet. That will disclose order dated 26th of December 2002. Petitioner is personally present.
Okay, 1 and
1 to 3 are also present, and other opposite parties are absent on call. Heard them on
you
admission.
Just take instruction.
Again.
You just take instruction as to whether here the OP 6.
Yes, was hard or not?
Page 12.
Again.
No, were noticed or not even?
Yes.
Again.
This writ petition is filed. The writ petition involved order 26/12/2002, but filed in the year 2023. Bracket 4/5/23. On the question of delay in bringing such litigation, Sri Datta Learned Counsel appearing for the petitioner submits is a subsequent purchaser from the OP number 6 as appearing at in the proceeding appearing at Annexure 2. It is there is serious allegation that the proceeding Annexure 2 was decided even without notice to the vendor of the petitioner.
Original vendor, my lords, because I am purchasing from opposite number 6 to 8.
Copies be served on State Council, who is directed to take instruction as to the position On the notice on OP number 6 in consultation division 305/99. How much time you want? This record will be available or not?
Yes, yes, it is available because I am having the certified copy I obtained recently.
Okay, you just take instruction. I'm calling it after 10 days.
15 days, तो 2 सप्ताह रखी दियंतु so that
15 days हेले आज केते तारीख हेला 17 7th of August. Place the matter again on 7th of August. On which date the grounds raised here in assuming an order after so many years would be considered.
Item 4.
In item 4, my lord, just now I received the counter.
Today I am filing the counter. I have already supplied the copy of the counter.
Okay, it is stated a counter affidavit has been filed by development authorities. With service of copy of the same on the counsel for petitioner. Counsel for petitioner seeks time. Place this matter 3 weeks after interim order to continue.
I humbly pray your lordship may be taken up 2 weeks after, my lord.
2 weeks after, all right, 2 weeks after.
Obliged.
Interim order to continue.
Great.
Item 5.
May it please your lordship. Matter is covered in matter of your lordship's order judgment. I have annexed it at Annex 6, my lord, at Lakshmi Rani Kashyap, Sambalpur urban matter. Recently, your lordship has
What
passed.
do you say, state council?
I had a cover coach. Cover coach.
Covered means the same similar judgment will be passed.
Yes.
Go area re keta.
Sambalpur.
Sambalpur, okay, all right. Same line there. What?
3 matters.
Sambalpur is already exempted. Already exempted.
3 matters.
All these cases, 3 cases are there.
Obliged, ma'am.
Item 6.
May I plead the lordship? I seek for a pass over, your lordship. The conducting council. May I seek for a pass over, your lordship? The conducting council is.
I seek for adjournment.
Pass over, your lordship.
Pass over it is 9.
Okay, your lordship.
Oh.
If there will be a short
Day after
adjournment.
tomorrow.
Obliged, your lordship.
Item 7.
In item 7, your lordship has directed the Tahsildar Barango to produce the record of right mind.
Sorry.
In item 7, your lordship has directed Tahsildar Barango to produce the record of right mind.
Yes. Though we have intimated on 10th of July 2023. এই 10 তারিখ আমি দিয়েছি পাইনি রিসিভ করিনি
So
from this তহসিলদার বারাঙ্গ
আসেনি
না এই 10/7 ରେ আমি চিঠি ଦେଇଛୁ ମ୍ୟାଟର was listed on 5/7 ରେ ଥିଲା ଚିଠି ଗଲା 10 ରେ
So how much time you want?
ଆଉ 10 ଦିନ ଖଣ୍ଡେ ସମୟ ଦିଅନ୍ତୁ 10 days
ଏଟା ତହସିଲଦାର ବାରଙ୍ଗ ପରା
ଆଜ୍ଞା ଆଜ୍ଞା
ଆଉ ତହସିଲଦାର ବାରଙ୍ଗ ତ ପୋଲ ଟପିଲେ ବସ୍ ଷ୍ଟାଣ୍ଡରେ ଲେଖା ହେଲାଣି ବାରଙ୍ଗ ବସ୍ ଷ୍ଟାଣ୍ଡ ବୋଲି
ନାଇଁ ସେଠି ଲେଖା ହେଲାଣି ଠିକ ଯେ to ensure
ନାଇଁ ପୋଲ ତଳକୁ ଓହ୍ଲେଇଲେ ସେଠି ଲେଖା ହେଇଗଲାଣି ବାରଙ୍ଗ ବସ୍ ଷ୍ଟାଣ୍ଡ ତ ଜଷ୍ଟ କିଲୋମିଟର away
ଆଜ୍ଞା ଆସୁ ନେକ୍ସଟ ୱିକ ନହେଲେ ଆସୁ
on the request of state council this who is yet to obtain instruction from the Tahsildar Barango place this matter on 27th ରେ ଆସୁ
ଆଜ୍ଞା
ହେଲା maximum time ଦିଆ ହଉଛି କରିଦିଅ
ହଁ ଆସି ଯାଇଛି ଆଜ୍ଞା ସେଟା କାଲିକି ରଖନ୍ତୁ ଆସି ମିଷ୍ଟର ସାହୁ has received
ପାଇଛନ୍ତି
ନା ସେ ତାଙ୍କର ମାନେ WhatsApp ରେ ପାଇଛନ୍ତି ସେ କାଲିକି ରଖି ଦିଅନ୍ତୁ ମାଟରଟା ସେ ତାକୁ
day after tomorrow
ଆଜ୍ଞା day after
day after yes
Mutation case was allowed in 20/12/2016.
pardon
Mutation case was allowed by the Tahsildar Kontapada.
right
But you may see page
and there is
15.
no correction of the record of right
Yes, that was directed and the Tahsildar was directed to the RK to correct the record. I have applied for the certified copy.
where is the order in mutation
That is a lot. You may see page 15.
Annexure 2
Yes, ma'am.
through document at page 2 Mishra, learned counsel for the petitioner claims, even though there has been a direction by the Tahsildar for it RI direction ଟା ତହସିଲଦାରଙ୍କର କାହିଁ
ନାଇଁ RI allow କରିଥିଲେ mutation case ଟା.
all right
That is
authority there is no preparation of corrected record of right and such simple action.
That has been confirmed by the Tahsildar.
not
Thereafter,
undertaken
Tahsildar
for
directed to
7
the RK.
Huh?
That was confirmed by the Tahsildar, that order of the RI.
Right, right. Such simple action is yet to be taken, pending for over 7 years, nearly 7 years. Considering there is already sufficient delay, this court observed in the event the order by page 14 and 15 remains intact. There should not be any difficulty in bringing in a corrected record of right. In the process, this court direct for bringing the corrected record of right in terms of the document page 14 and 15, at least within a period of 1.5 months from the date of communication of.
I have also applied the certified copy of that corrected ROR, Annexure 3. That was also in 25
No,
to.
no, you said there is no correction of the record of right as of now.
Hey.
There is already only a direction. So why is the question?
No, Lordship may see the next order, that is 21 to 2017.
Read.
The case record is put up today. Appeal period is over. Send the case record to RK for correction of
Therefore,
ROR.
action is to be taken in the preparation of the record of right. Appeal period is over. Therefore, I have observed in the event that order is not challenged.
Yes, 2017.
16 ରୁ ହେଲାଣି 17 ରେ ସେ order ହେଇଛି, ମୁଁ ଲେଖିଛି 7 ବର୍ଷ delay ହେଲାଣି.
ଆଜ୍ଞା.
Item 9.
May I please your lordship?
Yes.
Kindly see Annexure 2 series, page number 24. It seems that the appellant is present on 13/6/2017. But in the final order, it is reflected that the appellant is absent.
Not
Since
audible. Yes, what are you submitting?
it is ascertained that the appellant is absent since.
Which page you are reading?
Now I am 26. 26.
26.
Yes, ma'am. It is ascertained that the appellant is absent since 13/6/2017. The appellant is not interested to run this case. But in the order sheet, page number 24, it seems that 13/6/2017, the appellant is present.
26 is it order dated 16/5/18?
Yes, madam. Last line.
It is ascertained
That
that
the
the
appellant
appellant
is
is absent
since
the 13/6/17. Appellant is not interested to run this case. So dismissal. What is this proceeding?
Appeal is for mutation of ROR.
Okay,
Correction of ROR.
OSS proceeding. So what are you doing so long? Where is the certified copy of that order?
Certificate copy may be annexed here. Annexed here.
You have given only a Xerox copy. So establish through certified copy. We will believe these Xerox copies. Mr. SAHOO.
Next date I will
dismiss for default.
Dismiss for default, no doubt, but
What's
is it not appellable?
he can file restoration. Restoration file kariye.
Okay, on the ground of expert in nature, let us restore the matter and let him go and get a contract. But certified copy ta diyantu.
I will produce this.
How kebe produce karibe? Sign hela pare. Why are you in hurry? I don't find every day I find 10 such cases. Certified copy ta party deini apno kai dhadpad heiki rite file kar doutule.
Sorry, man.
There is no certified copy of impugned order annexure 3. In this circumstance, the writ is not entertainable. Considering the request of learned counsel for prisoner is permitted to bring the certified copy of the order sheet in suit number 387 of 16, available at page 25, 26 and 27 respectively. Hello. Yes, let the matter be called again on Monday. Asiva, apna another certified.
Yes, ma'am. Published.
Item 10.
Yes, may I please, John? Madam, in this case, I am coming to this challenging the miscase number 67 of 2021 pending before the additional Tahsildar Nischinkol, my lord. In the meantime, they have passed a order, my lord, in a death person without hearing the opposite party, and this also violating this honorable court's order. My lord, can you produce the certified copy yesterday I have received in this certified copy? My lord, can you see the
This is certified copy of which annexure?
and annexure in the copy. Annexure, they have not supplied the certified copy.
This is a certified copy of which annexure?
Receipt, madam.
Oh, this is a certified copy of which annexure?
Annexure, my lord.
ଆପଣ ଆଜି ଯୋଉଟା ଦଉଛନ୍ତି ସେଟା କୋଉ annexure ର certified copy?
4, annexure 4.
Annexure 4 page?
No, annexure 4, I have filed on the receipt of the certified copy application. They have not supplied. Yesterday, they have supplied another certified copy.
So how do you arrange this in the case record? It's not annexed.
No. But
therefore, withdraw and file a proper writ petition. How can we arrange? ଆପଣ ଏଠି ଦେଇଦେବେ କି ତାର pleading ନାହିଁ, ତାର annexing ହେଇନି.
No. My lord, they have not supplied.
They had not supplied. Now they have supplied. Now they have supplied. So you want to withdraw?
In this not compliance of the honorable court's order, my lord. Kindly in this order, say this certified copy, they clearly mentioned that there is.
How can I consider this now? It's not annexed.
No.
So you may have a cause of action, I don't say.
Yes.
But bring a proper writ petition so that I can consider. There is subsequent development after and prisoner comes to further development after the certified copy of order sheet provided. This court find difficulty in considering such certified copy or such order sheet, for there is no pleading nor annexing of such document. Prisoner is permitted to withdraw the writ application in order to bring a proper application. এটা ফেরই দিয়ে দাও। এটা भी দিয়ে দাও।
Item 11.
In item number 11, I am appearing on behalf of Mr. Dayananda Mahapatra for BDA, my lord. Here in this case, I will take instruction. Your lordship has granted.
You have received copy?
Yes, my lord.
You have given.
Earlier also there was a direction of this honorable court. My lord, they were supposed to take instruction, but they want further time, my lord.
Pardon?
Earlier also there was a direction for the BDA to take instruction whether this case is covered.
They want further time.
They want further time.
Okay, today there is request on behalf of Sri Mahapatra for further time to take instruction as per order dated 11/7/23. Kete 1 week will be sufficient.
Yes, yours.
Place this matter on 28th ରେ ଆସୁ ଆମେ ବ୍ୟସ୍ତ ରହିବୁ, ଆପଣ ମାନେ ବି ବ୍ୟସ୍ତ ରହିବେ, ପ୍ରେସିଡେଣ୍ଟ ଆସୁଛନ୍ତି। Both the matter same?
Same matter.
All right.
Grateful.
Next listening registry should indicate the name of Mr. Dayananda Mahapatra, counsel for opposite party. Yes.
May I please, Your Lordship. Challenging the inaction of the opposite party number 2 in not registering the revenue appeal of the petitioner, my lord. In regulation.
What happened? He is not receiving.
They received, my lord. I sent it through a registered post, my lord. They received the same, but not yet registered the same, my lord.
Not yet registered.
My lord.
You are sure it is received by them? It is
My lord.
registered post.
My lord.
Okay, petitioner through the writ application alleges the revenue appeal by annexure 6 being sent by registered post to the competent authority on 8/6/23 is yet to be registered. This court in the disposal of the writ application direct Collector District Magistrate Keonjhar to register the appeal in the event same is already in receipt of its office. received by its office and do the needful. Hello.
Till then,
It
I may
produce the copy of the order before the collector and district magistrate for working out the direction hearing, 3 copy the agent.
I may be protected, my lord. I may be protected for some time.
Pardon?
I may be protected for some time.
Protected सेठी appeal टा अछि आमे केन protect करू आपण decision देखंतु मोर अछि appeal हेले कोन हबो what will be the position of the order impugned therein देखछन decision माउ काई पढु नांदी पढंतु I have already given a decision no तो ए सब रे there is no question of interim order अछि statute रे अछि की collector तो order power नहीं so then how can read court grant a stay here? And you may take advantage of that judgment. The judgment what will be the position of property involved therein in such event. I have already given a judgment. Yes.
Item 13.
May I please, Your Lordship?
Yes.
The petitioner's passport was lost.
Today we are filing the counter affidavit.
Dion, copy Dion.
Copy is given. Already copy, sir. Just now copy, sir.
You are ready to argue?
So only the
Or you take instruction?
still only his passport has lost. It is valid up to 2031. And in lieu of the lost,
No, I am ready to take up the matter, but in the middle, don't say that yes, I'll take.
I have just now received. Your
So
Lordship, I can-
you
day after
submit to the court. I am batan paili mate 3 din antate diyontu. 2 din antate diyontu.
Yes.
You started arguing the matter.
I pray, my lords, day after.
That's why I made it clear. How mu pare debini samay.
Day after tomorrow, I propose. It is an urgent matter. That is why I am praying.
Yes, counter affidavit has been filed by Sri Padi DSC with copy, service of copy on the counsel for prisoner. Counsel for prisoner seeks at least 2 days time to take instruction. From the party involved, place the matter on Thursday.
Not
much of that.
Is Bobita so appearing with you, Lordship?
Bobita Samko Sangare also the DS. Right.
Item 14.
None appears for the petitioner. However, looking to the player involved within this court find the petitioner as a pending application by Dinosaur 5 series.
OP3.
Superintendent engineer rural was
OP3.
OP3, who is directed to take a lawful decision on the NSO 5 series hearing by completing the entire exercise at least within a period 2 months from the date of communication of order along with copy of lead petition. Yes.
Item 15.
My lord, last occasion, your lordship was directed to obtain instruction regarding auction amount. As for instruction, the 2 number of ponds has been auctioned.
Just Subhani, nothing is audible.
2 number of ponds has been auctioned. Amount
Ponds were auctioned when? Ponds were auctioned when?
auction on 12/6/2023.
12/6.
2023.
22. Are you a participant in the auction? खोजुचंदी कोन?
My participant is your village.
Are you a participant or not?
My lord.
Huh?
So notice ta publish kole nahi. हम जानी पारली नहीं.
That is your allegation.
My lord. और से जो allegation होची कोन हमर जो violation annex 2 टा violation कले जोटा कि लिखा है self help group मान को privilege दबा कथा. Women self help group मान को privilege न
What is the bid amount?
Bid amount is 96,000.
96,000. If the auction is already executed,
no agreement is signed. The only auction has happened. No agreement is signed.
no agreement signed.
My lord.
Issue notice on the question of admission considering there is serious allegation of two of the ponds indicated herein without proper notice. Admission shall, however, be subject to petitioner deposits a sum of rupees 96,000 in the registry of this court. Hello. Requisites as undertaken be filed by day after tomorrow. Matter be placed immediately after appearance of. किए नहीं बीट तांग पक्ष कहीं ये रमेश राउत आउ
Opposite party number 6 तांको रही. Opposite party number 6 my lord.
हाँ खाली दीटा को से नहीं जी
Dita से नहीं. Right.
okay after appearance of 4 and 5 and 6 है notice accordingly करियो all right deposit failure of deposit of the amount directed within 7 days matter will be dismissed without issuing further notice and without reference to further reference to bench even. So टंका आनी रखंदु ताले notice जीवो.
My lord.
I may be pardoned, my lord. Item 14, my lord. My link was failed, my lord.
14 कौन होगा? इटा बोले.
Item 14, my lord.
Non-appearance
Sorry, my lord. I was.
There
My
is
link
already
was
direction non-appearance tag taken out.
non-appears ta again tiye.
Okay, okay. काटी दे लिब्रा कोइली.
Again obliged. Taking into account the annexure 3 and 4 series, my lord.
ऐसे तो लिखी दो बार. Taking into account 5 टा pending अच्छी. Taking into account 3 and 4. Yes.
Obliged, madam. Obliged.
Yes. What is this, Mr. Jetty?
Item 16, my lord. This is inaction of the additional order, not publishing the ROR. It is covered by your lordship's order. I have given.
No, there is already an order for mutation.
There is an order for mutation, my lord.
ताको ओटा कॉपी दी चंदी.
Yeah, this.
Covered order.
I have.
Yes, all right. ऊपर भी करिबा. पूरा सब करेक्शन हो. पार्टिंग और ना सब. हला देखियो एटा वेरीफाई कर. Yes.
Obliged.
Item 17.
This is a covered matter, madam. Narottam Ratha ke asin.
Here, your lordship, in fact, I've examined the petition. In Narottam Ratha case, there was already an order under the OGLS Act. Here, there is no such order. They have not annexed any such order, your lordship.
Non-acceptance by the ASO.
No, non-acceptance when the OGLS case is there and there is a revisional order under the OGLS.
Okay. Even if it is not covered, even
Lordship.
if it is not covered, if he brings an application or he has already brought an application, give a lawful disposal.
We'll take a lawful disposal.
Okay. At the submission of land counsel for prisoner and state counsel. This court considers the allegation of the petitioner that an application brought by through annexure 5 before the ASO rental colony, Jobra settlement office Cuttack has not been accepted even. Considering the allegation, this court observed every application while observing every application brought before competent authority should see a lawful disposal. Permit the petitioner to retender the application by annexure 5 to the competent authority. This court, at least within a period of 7 days since, along with a copy of order, in such event, the competent authorities shall do well in giving a lawful disposal to the application involved therein. And after providing opportunity of contest to the parties likely to be affected, it is made clear. This court has not expressed any opinion on the merit in the entertainability or claim of the petitioner.
Okay.
Item 18.
If I may please your lordship, this writ petition is challenging the impugned order under Annexure 7, your lordship. This is the order passed in mutation appeal.
This is passed in mutation appeal.
Yes, your lordship.
What is your position in appeal?
My position is that, your lordship.
You are the respondent.
I am the respondent.
You are the respondent there.
Yes, your lordship.
What
The,
happened? He has recalled set aside the mutation order.
yes, your
It was
lordship.
in your favor,
Yes, your lordship.
but it's remanded.
It is remanded, but your lordship, it is also covered by one of your lordship's judgment, wherein it is categorically stated that once a civil suit is pending, a mutation appeal authority should not exercise any power if any matter is brought before him, because the question of final right, title and interest is pending before the competent
That's
court.
right, but this is mere preparation of record.
Yes, your lordship.
It doesn't neither create nor extinguish, right? So therefore, it will be always to the outcome in the civil suit.
Yes, your lordship. But your lordship, the person, the appellant here, he's a very moneyed man and he's a very powerful man. He has already initiated a lot of cases in.
No, then why don't you undisputedly on the self-same land, probably a suit is pending.
Yes, your lordship.
And consequently, Order 39 Rule 2 is also, 1 and 2 is also moved.
Yes, your lordship.
So why don't you obtain injunction on such property?
Injunction was granted in favor of the appellant, your lordship. The
Right.
same has been appealed. We have preferred appeal in the learned district court.
So
Your lordship.
appeal, it is reversed.
No, your lordship. It is pending for adjudication.
It is pending, therefore you are protected already. So no third party right can be created. So therefore, go and simply submit to the Tahsildar. I can say it will be, however, ultimate decision, subject to ultimate decision in the suit.
Much obliged, your lordship.
And will not give any private petition.
If creation of third party interest is prohibited till the pendency of
It is
the
only on the ground that
adjudication, then
I had the submission of Signia, learned counsel for the petitioner. The impugned order annexure 7 in appeal is challenged only on the premises that on the self-same issue, there is not only pendency of civil suit 482 of 18 involving a decree of permanent injunction, but there is also interim order of status quo involving the same land.
same land, your lordship.
Land involved herein in the disposal of IA 375 of 18. There is, however, fair statement that as against such interim order, appeal in the higher forum still pending. It is thus contended when the disputed property already got involved in a civil suit, there should not be undertaking of mutation exercise. For the opinion of this court, mutation exercise is simply for preparation of record of right bought on the existing right of parties. Preparation of record of right in this circumstance neither create nor extinguish right of the parties. Parties ultimately parties to the proceeding shall ultimately be abided by civil court judgment. Further, the impugned order involves an order of remand. For the observation herein above, even though this court declined to interfere in the impugned order, for the petitioner having sufficient scope to defend his case, undertaking the grounds, agitating the grounds raised herein for consideration of the original authority. This court simply observed not only the parties will be abided by the ultimate outcome in the mutation proceeding, but in the event the suit property already involved, disputed property already involved in the suit, and there has been continuing of a status quo order, no party will be permitted to create third party interest involving such property. And outcome in the mutation proceeding will also ultimately be abided by the ultimate judgment in the civil suit. Yes.
Much obliged, your lordship.
Item 19.
Lord,
Yes.
petitioner is an allottee one of one plot. that one plot has been allotted to the petitioner in Kalinga Bihar project, my lord.
Yes.
That since 1998. Thereafter, since 99, my lord, one adjacent plot is available to their house, my lord. So he has been approaching the VDA authority for allotment of the adjacent plot.
You are in possession of that?
Yes, yes.
No.
That kitchen garden is there.
Possession.
Yes, I am there.
Just one.
Thereafter, my lord, in 2020, my lord, an advertisement was floated by the VDA officials that a person who has been a allottee and an adjacent plot is available, then they may apply for additional plot.
Adjustment on premium.
Yes, yes. That is at my lord, Annexure 4 at page 19, my lord.
Yes. So
To
you
that
applied.
effect, my lord.
So you applied.
Yes, applied since 21, my lord. That is still pending. In the meantime, my lord, that Annexure 6, your lordship may kindly glance that notice was floated on.
Annexure 4 you have applied.
Yes.
No. Annexure 4 is the circular
Yes,
instruction of the.
pursuant to Annexure 4, that Annexure 5 applied. 5
Annexure
series.
5 is the application.
Yes, yes.
Now Annexure 6 is fresh notification.
Yes, that is auction notice was published for the self-same plot, my lord.
So there might be cancellation of this notification.
With due humility, I have taken instruction. Of course, I could not get instruction about what has happened to his application he has given because I could not trace out the file.
The question is, if the notification has been taken back.
No, fact remains. Kindly glance to again, I pray, Annexure 4.
4.
Because probably this is in the light of decision of minors. Minors have given a direction to the government and other authorities. That whatever minors said categorically, that if it remains undisposed of, not required for public purpose, then it can be allotted. That exactly in that light, that was the notification. One kind of glance to paragraph 3. The left out patches of land within the buildable area of the scheme, which cannot be used otherwise or developed as an independent residential or commercial plot, may be considered for allotment.
That is in terms of the judgment.
Right. Now, my lord, kindly glance to the area of the plot. Annexure 6, page 25.
Yes.
This is 1680. They say that can be carved out in an independent plot without affecting anybody, and this cannot be coming within the purview of.
Which page you are reading?
Annexure 6, page 25. The notification, the auction notice.
Same plot again.
Same plot. Now,
but that was a blanket notice.
That was a blanket notice. Pursuant to that, they applied for.
Now he has applied for.
But fact
remains notified on that plot. Specifically on that plot along with other
plots for auction.
So if such an application is pending, you take a decision.
Probably
that application may be treated as an application against this.
No,
or any
here means here in this case, they have to participate in auction process.
Now you will be auctioning. Then how his right is protected?
Right, minus fact remains it is an independent plot. He cannot get it. It is not coming within the purview of the criteria.
Then why don't you dispose his representation?
Exactly, I will take instruction.
It's not coming under the.
I will exactly. They are not getting the file where this application has been dealt with.
So file your affidavit.
Affidavit. I will be filing the affidavit. Minus may be taken up on Thursday. In between, I will be getting that. I have already instructed to get that file.
So what happened to that notification? Is it finalized?
This notification minutes. Annexure 4.
Annexure 6.
Annexure 6, but the auction will be fixed on minutes.
26.
Auction has been fixed to 26th.
Okay.
26/7 was the third line of the notice.
It's plot number kete eta?
Tini number serial. K9A/123. Very big plot. 1680. It is an independent plot.
So you say if it is an independent plot, can be allotted to
independent allottee, third party, independent allottee. These cannot be covered within the decision of minors or minors the circular.
Okay, then in that event, if he succeeds, he can participate in the tender process.
Yes, there is no problem in.
Are you applying here?
No, I have not applied.
Then you should have applied.
No, that application is still pending. To that effect, I have already deposited some amount.
Cannot be covered under this notice.
No, but my plot is there, my lord. In similar circumstances, your lordship may kindly glance another adjacent plus 1440 square foot that has been allotted.
Because that is
counter ASU.
Again.
ସେ ଯଦି କହିବେ ଯେ ଏଇଟା independent plot, ତାହେଲେ ଆପଣ allegation ଆଣିବେ ଯେ similar situation. There has been adjustment, so I have been victimized.
First of all, my application be disposed.
Okay, all right. କେବେ counter file କରିବେ?
ମୁଁ କାଉଣ୍ଟର କଣ ମୁଁ ଆଗ ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇ ଆସୁଛି ଗୁରୁବାର କାରଣ ଅଛି ଅକ୍ସନ
ନାଇଁ,
ଅଛି
ଆପଣ ଏକଦମ counter ନେଇ ଆସନ୍ତୁ ତାପରେ କେସ୍
ହଁ 26/7/2023 କି ଅକ୍ସନ ଅଛି ଇ ଅକ୍ସନ already auction process was over, but auction application was over by 23/6/2023. So I will take instruction whether the application has already been disposed of or not. First day or Friday, my let's pick it.
Person involves serious allegation to the effect
That I'm taking
being
instruction.
an applicant pursuant to
This
the
is this
advertisement
cannot
and
be parted.
SO4. Applicant by annexure 5 pursuant to advertisement and SO4. The application annexure 5 remaining undisposed, there has been notice issued inviting application from interested parties for auction sale of the very same plot K-9 capital A /1, 2, 3. Dayanand Mahapatra request for at least 3 days time to obtain instruction as to the development on the representation of the petitioner by annexure 5. Reach this matter on Friday.
That is not representation, my application for allotment.
Application for
Application along with the challan milo. That annexure 5 milo, that is my application for allotment in pursuant to the advertisement.
Now I understood, my lord. That is what the problem is. It is an application for allotment. Allotment cannot be made otherwise. So that is how probably this could not be considered. If it is a representation, if it is a representation,
Jadi heitle it's a closed chapter.
Closed
He
chapter.
has to challenge
Yes,
that.
yes.
Okay. Now, if it is not decided and pending, then find if his case can be considered for auction at least.
auction, the e-auction process is closed and cannot reopen.
Close ହେଇଗଲାଣି.
Close ହେଇଗଲାଣି ମତେ apply କଲେନି
Then there is bigger
23/6/2023
କେହି ଆସିଲେନି?
ଦେନି ଲୋକ ପାର୍ଟିସିପେଟ କରିଛନ୍ତି ଜଣା ପଡିବ ସେଟା ଆଜ୍ଞା 26/7
ଆଣନ୍ତୁ 3 ଦିନରେ 4
ମୁଁ
ଦିନରେ
ନେଇ
affidavit ଆଣନ୍ତୁ.
but fact remains
At the same, Dayanand Mahapatra, or at the same time also directed to bring on affidavit the further course of action pursuant to the notice annexure 6. The stage of the consideration process by annexure 6.
But actually, now I understood where the shoe pinches. What he has done is he has not filed a representation. He simply filed an application you allotment.
No.
That is why it could not be considered. We cannot be considered.
ଦେଖିବା ସେଦିନ ସେ ଯୋଉ ଦିଆ ହେଇଥିଲା ତା ଟାଇମ ଭିତରେ ଯଦି ନେଇ ହେଇଥିବ ତାହେଲେ but why are you not giving a disposal to?
Yes, that exactly I will take care. I will take note. My lords have already observed.
Item 20.
May I please, your lordship? The petitioners belongs to scheduled tribe community. They file an application for permission to sell their land to purchase another land.
Rejected.
Yes.
Rejected.
It's an appellate order, your lordship. Section 22, it has been rejected. Section 58, appeal lies.
Appeal ଅଛି.
My lords.
So why are you not preferring appeal, statutory appeal?
Section 23 revenue officer, the sub collector passed order.
Sub collector. Sub collector pass କରିଛନ୍ତି ଏଟା?
Yes, my lord.
Okay, sub collector ହେଲେ to the collector ହବ.
Yes.
ଦେଖେଇଲେ ଏଟା regulation 2 ତ? Oh, sorry.
OLR Act.
OLR ଦେଲ. ଦେଖନ୍ତୁ appeal ଟା ଲେଖା ହେଇଥିବ if so and so passing order then to so and so. 58 ନା?
Yes, my lord. Yes, my lord. Appeal against the
It is there, your lord.
22 order.
58. Section 58.
3. Subsection 3.
Subsection 1, your lordship.
Subsection 1.
Any person
aggrieved by an order passed under the following sections may prefer an appeal to the prescribed authority. Namely, section so and so. In that section 22 has been mentioned, your lordship.
22 is there.
Lordship.
There is no dispute. But his allegation is if it is 22 and decided by the sub-collector, then appeal lies to whom? And a revision, who is the prescribed authority for appeal? Yes, who is the prescribed authority for appeal?
ADM, my lord. ADM.
ADM. So ADM is certainly not sub-collector.
No.
So we file appeal.
Yes, my lord.
Yes, undisputedly there is remedy of statutory appeal involving the order at annexure 1. Petitioner has to withdraw the writ application in order to avail the statutory remedy appeal. For petitioner inadvertently pursuing his remedy in a writ court, this court, while permitting the petitioner to take return of the impugned order annexure 1, also permit the petitioner to bring the statutory appeal before the competent authority at least within a period of 10 days. In such event, the appeal shall be considered and disposed of on merit.
Obliged.
Yes.
Item 21.
Very limited prayer is to dispose of the case number 462 of 2016 as mentioned in annexure 5.
Dispose of the
Case number 462 of 2016 as mentioned in annexure
proceeding
5.
under what statute?
The proceeding under Survey Settlement Act.
The petitioner claims
Annexure 5, it has been mentioned annexure 5.
on pendency of the case number 462 of 2016 by annexure 5 before the competent authority, before the authority involved. This court, without expression of any opinion, disposes the writ petition directing the OP number.
OP number
Additional sub-collector.
3.
Kete OP?
3. OP number 3. It has been mentioned.
3.
My lord.
OP 3 for giving a lawful disposal to the proceeding by annexure 5 pending since 2022, May 2022. By giving an outcome at least within a period of 3 months, but however, we providing opportunity to the party likely to be affected. This observation, the writ petitions can be disposed. Yes.
Item 22.
May I please your lordships, I am in VC, my lord.
Yes.
Proceeding at 26 Orissa Gram Panchayat.
26.
26. Elected.
Allowed or rejected?
It was allowed against me.
Against you, then why 2 petitions?
No, 2. First is for one Sarpanch, the second is another was for ward member. 2 independent, other independent.
Yes, there also section 22 allowed.
26
Section
allowed.
26 allowed.
Allowed.
Then it has to be admitted only.
I know your lordship.
Then what miscase? Miscase cannot be entertained. You have been found to be disqualified.
Yes, yes. But then no opportunity was granted. That is something your lordship
That's a
is to
different
decide.
issue. On allying, maybe proceeding will be reopened. That's a different issue. But at this stage, no interim order. Rahul Gandhi admit kar diyo, call for record in the section 26 proceeding from the office of collector and so. Requisites accordingly karibo. Matter may be listed in the second working week of October. Yes.
October, September hawani.
नहीं सेप्टेम्बर हेई परियोनी आज्ञा सेप्टेम्बर रे मोर बहुत कम दिन
आपण कम दिन से फिलअप हे जो आपण सुनि छी
ता परे आसीबो
your lordships covered judgments. That's why I'm saying we no opportunity granted.
कोन करिया मु ता मते कोन आपण एक्सटेंशन देई परिबे कॉन्स्टिट्यूशन तो नाही
देई परिबे मु जदी सुप्रीम कोर्ट हमर रेफरेंस कला
सुविधा नाही ତେଣୁ ନୂଆ ଜଜ୍ ଆସିବେ ଶୁଣିବେ ଆଉ କାହିଁ ବ୍ୟସ୍ତ
Sir, I am praying for a September ଯଦି ହେଇପାରିବ।
କେମିତି ହବ all at once ଲେଖିଦିଅ place the matter immediately after appearance of the contesting opposite party ସେ ସେଇଟା ଦେଖିଦେଲେ ସେ ଦିଥର ନୋଟିସ ଫେରେଇ ଦବ ସେ ସେଇଟା ଦେଖିଲେ ଦିଥର ନୋଟିସ ଫେରେଇବ କହିବ ହାକିମ ଯାଆନ୍ତୁ ୟାଙ୍କ ଅର୍ଡର କଭର ମାଗିଛନ୍ତି ଦିଟା ଯାକ ମ୍ୟାଟର ସେୟା ହବ ନା yes next
Revision
Item
petition
23.
pending for fresh admission.
Fresh admission.
Fresh admission.
Your lordship is issued notices on both the matters.
pardon
Both the matters same order.
yes same order এটা খালি fresh notice these are all matters of 23 case
26 your lordship.
no I am in a different case
First one,
My lord, sorry your lordship.
first one is 21.
okay देखियो वाला case number देखी करे yes
Item 24.
तीनटा मैटर আছে তিনটা আগর কেস নম্বর দেখিও yes
May I please the Lord? My Lord, the petitioner,
24
item 24.
yes
My Lord, the petitioner in this case is aggrieved by the order which is annexed as Annexure 1, page 11 of the additional Tahsildar, by virtue of which the land demarcation has been done without any intimation or notice to the petitioner. The land actually belongs to the petitioner's father and the
why you are a appellate holder
My Lord,
You are
I
ma-
am the legal heir. The land belongs to my father. And in this case, the opposite party number 3
your father's land has been measured
has been measured. But at the same time, there is
who is the occupier presently
the petitioner as well as the petitioner's sister, who is opposite party number 3.
they are in occupation
Yes, they all are, and the petitioner's
Then
mother.
how the measurement took place without their involvement
In fact, the partition has also been done without her knowledge, which has been done by the Tahsildar under OLR 19(1)C, and the same is challenged in an appeal. While the appeal is pending, this demarcation has taken place. And the petitioner did not even know about it when she returns back from
Okay,
school.
there is no appeal provision
Lordship,
there is no appeal
There is no
Let
appeal
the
provision.
notice go of the cure.
Lordship,
There is serious allegation of conclusion of a demarcation proceeding without involvement of the landowner. There involved private party likely to be affected. This court direct issuing notice on OP number 3 and 4, requisites for which will be filed by day after tomorrow. State Council will be provided 2 extra copies will be appearing for OP number 1 and 2. State Council is also directed to call for the keep the record in demarcation case 321 of 23 for perusal of the court to find the allegation of the petitioner if correct or incorrect. Okay, you may file also small affidavit whether he
Lordship.
was involved or not.
Lordship.
And also obtain instruction from the Tahsildar whether he is the actual owner of the property.
my lords.
Lordship, any third party, right, that maybe there is a risk that the opposite parties may transfer the land to some other third party.
Demarcation case, no interim protection can be given. If your right is going to be affected, you can very well approach the civil court to
Lordship, my
get
appeal-
injunction, but demarcation case, we can't grant any status quo. It is only for preparation of a report for the convenience of party. It doesn't create any right. किए property ଉପରେ କିଏ ଅଛି property ର details ଆସିବ ଚୌହଦି ହବ ମାପ ହବ 15 ଫୁଟ ରେ 20 ଫୁଟ କି 22 ଫୁଟ ରେ 48 ଫୁଟ ସେତିକି that's all. It doesn't create right in favor of any party so that ତାକୁ ନେଇକିରି ଜଣେ ବିକି ଦବ କେମିତି ହବ?
Lordship, severe
Find out
inconvenience.
what other options are available. No interim order possible, madam.
My
This case रे भी notice कर दे. Yes, next. First contempt.
Item
20.
25.
Second contempt.
Second
25,
contempt. Yes.
25, my lord, I have received instruction. Here, my lord, your lordship may kindly see that now the plot belongs to government, my lord. So we are unable to receive rent from the petitioner.
Then what was the direction there?
Direction to receive rent.
Page 8, my lord. Your lordship can peruse page 8, the operating portion of the order.
Oh, so you say, then what is the remedy available with you, Mr. Panda? Suppose this court has directed to accept the rent. Now, it was in contest of the matter. Maybe at the fresh admission stage, there is disposal. If you find inconvenience, what is the remedy? Should you come with a response in a contempt, or is there any other? So therefore, approach
Yes,
under appropriate remedy.
Yes, sir.
The impugned order was passed after thorough hearing, my lord.
That's
That is
right,
there.
that's right. But now that they find the property belongs to state, how can they receive rent from you?
Despite that, my lord, considering that the direction was issued to accept the rent without prejudice to the claim of the
No,
petitioner.
no, it can't be.
They are
And
not,
it is of government. How can they receive rent from you?
they could have passed
So
an
in
order to
that,
that
yes,
effect.
that's why,
They are not
they have
passing.
to move the read court for variation of the order.
Yes,
If they fail, then you get a chance for contempt.
my lord.
ହେଲା ତେଣୁ ମୁଁ ଖାଲି adjourn କରିଦଉଛି for 2 weeks. In the meantime, they let them find out. Adjourn the matter for 2 weeks. କିଛି ଲେଖା ହବନି. ଆପଣ ସେପଟରେ ଜଗନ୍ତୁ. Yes, next.
Item 26.
26 in item, my lord, last occasion directed to recall the letter under annexure 3.
Already.
There's a clarification, Lordships, last two paragraphs, Lordships.
Yes,
Last
therefore, the
paragraph.
above para so need not be acted upon instead of the following.
Aye.
In enclosing here is the copy of ete past and ete, I am to direct you to go through the same and do the needful as per direction of the court. So
ଏଇଟା
therefore,
ହେଲାନି କାହିଁକି ନା ଏଇ ଆପଣଙ୍କର ସେ ଅର୍ଡର ଟାକୁ ରେଫର କରିକି କୌଣସି ଲେଟର ଏ କେସରେ ସିଆର କରିବାର ଅଥରିଟି ନାହିଁ କାହିଁକି ନା ଅଲରେଡି ଆପଣ ଡାଇରେକ୍ସନ କଲେ କାହାକୁ ନା ତହସିଲଦାରକୁ ତହସିଲଦାର କଣ କଲା
ଆମ direction କଣ ଥିଲା
ଆପଣ
ଦେଖିବା.
ଡାଇରେକ୍ସନ କରିଥିଲେ ପିଟିସନର
para 5 ପଢନ୍ତୁ.
ଆଜ୍ଞା para 5 ରେ ଲେଖିଲେ ଯେ ଲାଷ୍ଟ କୁ ଲେଖା ହେଇଛି ଯେ ତହସିଲଦାର shall do well in considering the grounds raised by the petitioner while taking decision on the issue involved there.
ପୁରା ପାରାଟା ପଢନ୍ତୁ.
ଆଜ୍ଞା. In above view of the matter, this court, while declining to entertain the writ petition at this stage, keeping the matter for consideration of the Tahsildar, but however, considering the submission of the learned counsel for the petitioner that the petitioner is not even a party to the proceeding by the annexure 2, this court observes in the event the proceeding involving the notice at annexure 2 is still under
So
adjudication.
therefore, your objection will be considered. Your objection will be considered. What is the objection?
Tahsildar, after receiving the order of the your
You had
lordship,
already recalled that person.
that person no, referring particularly what I submit before the lordship is that referring the order of this honorable court, he cannot write in letter to the Tahsildar because of this has been disposed of by the Tahsildar in compliance to the order of this honorable. That is my lord.
Not.
That is my lord.
He has not decided anything, Mr. Counsel.
My lord.
He has not decided. He said that para is taken out.
My lord.
Now the Tahsildar will consider in accordance with the direction of the.
Sir, already
That's
disposed
all.
of ହେଇଯାଇଛି ପରା?
Sorry, I am not here to teach you. Yes, Lekha, there is submission of further clarification.
My lord, may I kindly pardon to
Clarificatory letter from the additional assistant commissioner of endowment, virtually withdrawing the communication impugned in the content proceeding in the circumstance. And in the interest of justice, the authority under the direction of this court in the disposal of the WPC 19821 of 22 take a lawful decision strictly in terms of the High Court direction. The communication presented here, communication of the additional assistant commissioner presented here may not be construed to be influencing the competent authority in any manner. Now with this observation, the content proceedings stand dropped. Taku a copy de diyon.
I did check.
Yes.
Soft copy as well as hard.
Not to have.
I have told him not to overstep.
Not to have any influence.
I have told him not to overstep.
You should not have issued such letter. He's a judicial officer.
Yes, Your Lordships. I've done. Oblige, Your Lordships.
Item 27.
May
Fast
please your lordship,
contempt.
fast contempt, your lordship.
Fast
On compliance of order dated 16.
Fast contempt.
Item 28.
My lord, 28, my lord, 28, my lord. 28, I have received instruction, my lord. Your lordship may kindly see, pursuant to your lordship's direction. Now, Tahsildar already completing his formality, now it is submitted to the sub-collector for approval.
ତାହେଲେ ଆଉ ଗୋଟେ ମାସ ଦେଇଦବା ତା ଭିତରେ ସବୁ ଆଉଟକମ୍ ଆସିଯିବ।
My lord.
ये फर्स्ट कंटेम्प्ट डिस्पोज कर दियो। डेवलपमेंट इफ एनी in terms of the direction of the read court be taking place at least within a period of further period of 1 month. Instruction memo submitted will be kept on record.
Another 4200. Out 4200. Another same.
Same order.
29 already complied, my lord.
29 already complied. Oh, ସେଥିରେ ଦିଟା କେସ୍ ଅଛି ହେଲା contempt ଦିଟା ଅଛି ଦିଟା ଆଗରେ ଦିଟା ଦେଇଛନ୍ତି communication.
Statement learned senior survey copy.
ଗୋଟେ କପି ଟେ ଦେଇ ଦିଅନ୍ତୁ ତାଙ୍କୁ।
हाँ, दे दो।
Shri Panda appearing for the contempt of submits. ଏଇଟା କଣ direction ହେଇଥିଲା କି read ରେ?
Lordship page
The
9.
lordship may direction are to comply section 4E of the PESA Act.
Lordship.
Okay, have been fully complied.
Yes, yes.
Okay, then find out other options if any available.
Let my lord senior survey copy
Yes.
because I have filed. I have no
Instruction memo
There
has
is
been
no
filed in the contempt application. And Shri Panda, in reference to the same, claims there has already been compliance of the direction of this court. For this development, this court find nothing survives. Petitioner, if still feels aggrieved, may find out other options available.
For orders, item 30.
Item number 30, please.
My lord friend has filed an application for vacation of interim order. No, that I submit, my lord, matter may be had and disposed of.
My lord.
Since interim order has been.
Vacation of status quo.
My lord,
Hearing he Mr. Mahathi.
my lord.
So, and nor
Like today,
vacation of stay is possible.
No, my submission is, my lord, today IA number 4661 of 2021. This is come up today, my lord. For
He's
order.
challenging, my lord, 15B order.
15, no.
Be ordered
I'm not
to-
there, my lord, but during pendant, my humble submission, my lord.
She
The
is for
status.
vacating. He is for vacating.
No, my lord, that is different, my lord. 4661 IA for order 39 rule 2A, my lord. What
IA
happened?
4661.
One, my lordship.
Flag C. Yes, what is your application?
My lord. My humble submission, my lord. At the instance of the petitioner, my lord, status quo order was passed by this honorable court, my lord, on the disputed plot, my lord. And during the pendency and existence of the status quo order, my
Don't
lord.
go to merit. Don't go to merit.
No, I'm not going to the merit, my lord. I am-
Then what is the
Yes,
reason for vacating?
This is not my vacation person, my lord. Stay
Yes,
vacation.
yes, also
4661 of
sorry,
21.
4116, sir, 4661.
466.
Then what is this application? To punish the petitioner under order 39 rule 2A.
My lord.
Oh, you allege he has rather violated the,
Violate this order of
and
status
then
quo.
let
my lord.
him file objection.
Lord, I'll
You-
file objection.
you
I
file
have to
objection
take
to
instruction
it.
and file objection.
This is an application alleging violation of the status quo order by the petitioner himself. Okay, Sri Mahanti Learned Counsel appearing for the petitioner seeks 2 weeks time to bring an objection to the said application. Place this matter after the objection comes on record. Interim order to continue.
Lordships have fixed a date.
Lordship, fix a date, lordship. Date, lordship. Lordship, fix a date, lordship.
Date ଆଉ ଆଜ୍ଞା ସବୁ କେସ୍ ହେଇପାରିବନି। Yes, ଦେଖା ହବ ଯଦି ସେ violate କରିଛି he will be punished. So why are you anxious for a date?
Date, lordship, fix a date, lordship.
Item 31.
It will not be listed.
My lord, item 31 on behalf of Mr. Palit, senior advocate, my lord, we have for the petitioner, my lord. We have for the petitioner minor, will remove the defect within a week minor.
Removal of defect.
Removal defect. As an order. On order dated 14/9/2021, paragraph 3, opposite party number 3 has to be represented by the commissioner instead of executive
notice to issue ହେଇଯାଇଥିଲା ସେ correction ଟା ହେଲାଣି
Correction
direction ହେଲାଣି 9/21 ରୁ
sorry madam.
September 21 ରୁ ହେଲାଣି
We are sorry madam.
council is provided council for petitioner
1
is
week time is
provided.
kindly allowed.
1 week as a matter of last chance to work out remove the defect pointed out and permitted by the order dated 14/9/21. Failure of removing the defect shall be construed petitioner having no interest in
No, sorry madam, 3 days madam.
7 दिन देली
With madam.
7 दिन देली
Oh,
3 दिन काई
obliged.
7 दिन रे न कले dismiss हे जो without reference to bench.
Item 32.
In this matter, this matter may can be taken up along with IN number 205 of 23. That is for condonation of delay.
Paper publication करिवे, they are not receiving. Direction ହେଇଥିଲା paper publication ପାଇଁ
नहीं
item 32 तो
आज्ञा
it's a restoration matter.
Yes.
Restoration हेले petitioner रे repetition रे जी सब appear करथले तम copy दउ नांदी. If they receive notice, I may not issue notice.
I will short copy.
Otherwise, I will be issuing notice. Place the matter Thursday. In the meantime, the counsel for petitioner is permitted to copy of the CMAPL on the counsels already appearing for respective opposite parties in the petition involved herein. Also. आगो दउनांती कि नोटिस ने नेले एका 2 वर्ष लागिवो से नोटिस सब्सेंट हे परन
I will short copy.
यदि आसले छिडा ले रेस्टोर कर दवा.
Item 33.
May I please, your lordship. The work has been allotted under
Yes,
Annex 1.
exactly.
I am appealing
Work
for
has
one-
been allotted in favor of the present petitioner. Under
Pardon?
work has been allotted, my lord, in favor of the present.
No, no, wrong. आदि orders में ऐसी अपन merit को पढ़ेलें.
No, it was not
Please, your
listed on
Orders कौन है
Monday.
जी?
It was
Person
listed on
to post
Monday.
Order number so and so, counter not received.
Counter I have not filed.
So why are you not filing counter? It's a 2023 matter.
So 1 week time.
So
may be allowed.
when you will file counter?
After 1 week. or so.
1 week.
Only
Because
my lord,
already, my lord,
only my lord, I
annexer.
have completed my work. Check was issued in my favor. Subsequently, it was stopped. Only
Notice
it has-
issue इचना नहीं कहले.
Again?
Notice issue इचना नहीं.
Again.
So counter is required or not?
Your lordship,
अब बिना counter रे allow कर दी सिर्फ धड़ किना उठे रीट अपील में order भीतर. काहीं से उड़ा करते.
After 1 week. or so.
Place the matter 2 weeks after date कर दिया. The Patti Learned Counsel is directed to bring the counter affidavit on behalf of the contest opposite party. One the state of Orissa. आपको कौन state of Orissa में आपके कुछ?
OLIC.
Lift irrigation.
State of Odisha is not a party.
Lift irrigation.
Lift irrigation. Corporation and executive division.
But cost title shows state of Orissa. Order sheet रे.
Order sheet.
Order sheet टा wrong हो चुकी. हाँ ये अच्छी तो P1 अच्छी अपन 2 पे appear करचंदी.
आज्ञा.
Executive role ऐसी. So 2 खाली लेखा. 1 अच्छी chief secretary.
OP number 2 against
नहीं,
allegation.
2 पे ये देवे.
ना सेटा correction ହେଇଛି MD OLIC ଲେଖା ହେଇଛି ଉପରେ hand ହାତ କରି.
Okay, okay. ପରେ correction ହେଇଯାଇଛି. ଆଉ state of Orissa କାଇଁ ଲେଖା ହେଲା ସେ ତ କଟା ହେଇଗଲାନି ବାକି ସବୁ କଟା ହେଇଗଲା.
I have also
ଲେଖା ହେଲା
filed
state
वकालत
of
number for
Orissa
1.
recommended through additional chief secretary to government ताପରେ MD Orissa lift irrigation. किए correction करछि आगु Mr. महापात्र.
No, my lord.
Your handiwork.
I-
काटन दो ठीक से.
My lord, cut.
यदि lift irrigation हला party state of Orissa recommended by additional
No,
chief
no, my
secretary
lord.
काहे की रहइबो.
My lord.
काटन. काटी आज का डेट एंडोर्स करंतु 1 and 2 हला.
Pardon me, Lord, item number 30.
34, if anybody has obstruction in the intervention application.
Lord, I may pardon me, Lord, item number 30, interim order is still today.
Interim order continue ହେଇଛି
Interim order is still.
continue ହେଲା item 30 ରେ
ସବୁଥିରେ continue.
item
In this
34
case, my lord, I am appearing for intervention, my lord. I have filed the intervention.
So
I have
let
filed
the petitioner say if you have any objection for intervention,
I will file my objection, my lord. I
you
will
will file your objection.
my-
Oh, who are you, Mr. Jethi?
I am the, my intervener is the
Oh,
complaint.
intervener Chadantu, what is your interest in
I
the
am the-
property?
Interest, my lord, I am the next house owner on which plot deviating my constructing nearer to my plot, no, having no setback. He has constructed G+3 building, whereas his plan was approved for G+2, my lord. And he has,
Have you raised a complaint before the development authority?
yes, my lord, basing upon my complaint, the UC case has been instituted 12 of 2023, and your lordship.
That is pending on self-same land.
Your lordship has, they have come challenging that UC case, initiation of UC case, and
Then who has come here?
the same petitioner, my lord. I will apprise your lordship within 2 minutes, my lord. What happened in this case,
So
my
your
lord?
allegation, it is in suppression of facts.
Yes, my lord. My lord, your lordship has earlier in WPC
Let
number.
him be added, let him bring the counter.
Let me, I file an objection, let me.
What objection you will bring?
I have here no
He
locus
has an
standing.
interest over that property.
No,
I'm
but-
not deciding any merit right now in his favor. You will only be given right of audience. And an objection.
I'll file, let me file an objection, because Mahadi, my
For
lord.
the petitioner insists on filing an affidavit. Objection. Bring an objection to the intervention application involved herein. Let an objection be filed by end of this week. Place this matter on next Monday.
May I pray, my lord? He is moving with the construction in spite of there is a direction not to do.
देखियो interim measure तो अच्छी.
By virtue of that interim
This
measure.
CUC case is filed by you.
By my.
12/2023.
Yes, my lord. Basing upon my complaint, the authority has
CMC has
instituted,
filed.
CMC has instituted the UC case. my lord.
All right, let his.
Your lordship has disposed, direction to dispose of the UC case within 3 months. Challenging that order, again, he has filed one writ petition, my lord. In writ petition on 12/6 during vacation, he has obtained an interim order, stay order, this order, and going on construction.
The objection, thereafter I'll pass the final order.
Obliged, my lord.
interim order
Obliged,
to
my lord.
continue, my lord. Interim order is there.
What interim order will continue? There is suppression of material fact.
No, my lord, no suppression. I'll file my update all.
ମୁଁ ଆଜ୍ଞା କରିଛି ମୁଁ ହାଇକୋର୍ଟ ଗୋଟେ ରିଟ୍ ରେ ଅର୍ଡର ନେଇଛି ଡିସ୍ପୋଜାଲ ପାଇଁ of that.
In fact, what I instruction.
Stay of that proceeding. Where have you stated that there is a writ petition?
I have quoted, my
direction?
lord. I have quoted.
You have quoted.
I have quoted.
Annex also that order. Your
I have
lordship's
quoted.
order has been annexed, my lord. Your
Oh,
lordship-
yes, it is vacation court.
Eight.
That's why all these things are happening. So sorry.
Interim order to continue only on till Monday, my lord.
Sorry, I will not extend the interim order.
Stay of my.
No. Sorry.
Obliged,
Vacation court, they have no time to apply their mind. They asila taku stay de diyo. Yes, all other hearing matters will remain in the list. Will remain in the list. No, ସବୁଦିନ ଏଥିରୁ ଗୋଟେ ଦେଇଦିଅ ହେଲା। ସବୁ ଦିନର list ରେ ଗୋଟେ add କରିଦବ। Interim order wherever there to continue. Yes, correction ये फाइल करथिले कहां के काउंसर? हाँ, Mr. Sinha.
Take back certain document.
Mr. Sinha is in second matter. First matter ta clear अछंदी. Josna Rani Rathore. Yes, what is the mistake?
Correction.
What typographical error?
Clerical error. Let's see. In place of the plot number.
Mic टा down करंदो.
Plot number hal 552/1908. Wrongly mentioned.
कोठी लेखा हैची.
I am
Plot number code लेखा हैची.
Order sheet dated 11th July 23.
No, you are placing from judgment 11/7/23.
Yes, Lordship.
तारी देरे prayer रे जो plot लिखा है इसका.
Yes, sir.
Okay, now come to your read petition. Let us see what is your prayer. Yes, in the read petition, what is your prayer?
Yes, Lordship, in the prayer, last, further be pleased and further be pleased to issue writ, mandamus or any other appropriate.
Read the prayer ta padhandu. Read the prayer number 3 padhandu. Seta iti Roman 2 hichi. Prayer number Roman 2 ta padhandu.
Prayer number 3, that the properties are in dispute which relates to Sabik Mauja.
No. Further be pleased to armo hichi apankar kon alga achi prayer.
In my plaint and prayer, I have mentioned that.
No, in the prayer padhandu apon read the prayer ago padhandu apon kouchandi plot number bhul lekha hichi na nahi.
Yes, Lordship.
हाँ आपको प्रेयर टा पढ़ले जना पड़ियो प्लॉट नंबर टा भूल अछि कि नहीं मु आपको प्लेयर को प्रेयर टा कोट करा हिची लागुची आपण कोन करेक्शन चाहुछन दैट्स immaterial.
Yes,
it is to be seen whether it is in consonance with your prayer or not, because this is quotation of the prayer. Read the prayer paunandi. Come to page 13 of the read petition.
Further be pleased.
Yes, pardon,
Yes,
sir.
sir. And further be pleased to issue a writ of mandamus or any other appropriate writs or direction order or orders directing the OP number 4 Tahsildar Cuttack Sadar to correct the HAL Khatian number 325 HAL plural number 548 area 504 decimal HAL plot number 551 area 354 decimal HAL plot number 552 oblique 1098 area 1098 area, Lordship.
That 1098 is typed as 1908.
Yes.
या तो भूल
Yes,
ହେଇଛି ହଁ
yes.
ସେଠି ଆଣିବେ ନା ଆପଣ
Yes.
ଅଲଗା ଆଡେ ପଢି ଯାଉଛନ୍ତି
Sir.
ସେ ଏଇଟା ପଢିଦେଲେ ଜଣା ପଡିଯିବ ଆମର ମିଷ୍ଟେକ୍ ହେଇଛି କି ନାହିଁ ହଁ ଆଉ କଣ ମିଷ୍ଟେକ୍ ଅଛି it will be corrected ଏଇଟା ଭୁଲ ଲେଖା ହେଇଛି
All
Yes,
are
it is our mistake
officially.
ହେଲା ଏଇଟା 1098 ହବ ଆଉ ସବୁ ଠିକ ଅଛି
Yes, sir.
all right ସେଇଠି ଡ୍ରାଇଭ କରିବେ ନା ଆଉ
Sir, this is the matter of Miss J.R. Ratha. She is absent today.
sometimes there is mistake it is human eye.
Yes.
Error is also possible this side.
Obliged.
Quotation allowed कि भूल पर चला. Yes, it is stand corrected. Out yes, second dash on Mr. Sinha. What is the mistake?
Certified copies I will take back. Certified copies of annexures.
Oh, you have asked for the return of the certified
My
copy of annexure. Annexure
3 की 4 into भूल गए आयरे लिखा है
किसी लिखी ना दी खाली
हाँ ना आयरे लिखा
और 2 and 2 by 1
आगे
2 and 2 by 1
those copies are there with the petition extra add
2 टा खत्यान टा
आगे
2 by 1 टा इटा map टा all right yes अच्छी जेरॉक्स कॉपी देइछंती की
जेरॉक्स कॉपी देइछि
Xerox copy nahi bodhe.
Read sangraj.
Okay. Lekha, this is an application for return of the certified copy of annexure 2 and 2 by 1. Running page 10 to 12. Rest is directed to return both the certified copies after retaining Xerox true copy of both the documents. With this order, the miscase stand disposed.